You need to use it.
We need to go.
Yeah, I'm gonna let Scott introduce you.
Okay.
All right, well, welcome back, everyone. We are starting our afternoon portion of the workshop. We're going to start out with Jennifer Roth, who has graciously come to speak with us about the Kansas Offender Registration Act to continue our discussion of offender registration. Jen is a former commission member and is currently with the Appellate Defender's Office. She has been a public defender for 26 years. And has done trial work and then came back to the ADO. And of course, she's currently the deputy. Jen could easily be described as the subject matter expert on offender registration in Kansas. So we are very fortunate to have her talk through, she's already indicated here, her a walkthrough of the statutory case law and prior legislative proposal overview. So we're very happy to, she has served on many legislative as well as other committees that deal with criminal justice. And with that, I will hand it over to Jim. Thank you so much for being here.
Thank you, and thank you for having me. As Scott said, I've been a public defender for 26 years. I calculated that I think I've testified at the legislature about 200 times. And I mean, a good portion of them were about registration. So one thing that I'm pleased that I have is an institutional memory of proposals and how we got the laws we have and things like that. And so that's one of the things I want to talk to you about today. So what I hope to cover today is basically how we got to the place that we are over the last 31 years, how the appellate courts have repeatedly upheld core requirements. One thing that people might be asking themselves, although you all are seasoned and probably know the answer to this question, but if core is in fact a civil regulatory scheme and not part of one sentence, then why are we talking about it here? I have lots of answers for that. And finally, what the Sentencing Commission and other groups have proposed in the past to modify the Kansas Offender Registration Act. So and the other thing is I'm going to go through this pretty quickly because you have in your packet my PowerPoint, which I actually made myself a note to tell you that I'm really sorry that I'm really bad at PowerPoint. I mean, you're going to see like screen grabs, you know, I'm just not that great at it, but especially when it was trying to double as a substantive material. So I'm just giving you my apology in advance about that. But this entire presentation is in your packet. And there's also a chart in your packet and available on the commission's website that actually shows you year by year what changed with offender registry. So this started, our first registration act in Kansas was 1993. It was called the Habitual Sex Offender Registration Act. It required registration for 10 years. If you didn't comply, it was a Class A misdemeanor, and it was only for people who've been convicted of sexually violent crime a second time. The year after that, they amended it, and that is because before this amendment, a person who was a registered sex offender killed a young woman, Stephanie Schmidt, in Pittsburgh, Kansas. And so folks came to the legislature and said, we want to expand the act to people who's their first offense. But other than that, the stuff stayed the same as far as what offenses were registerable, the penalty for it, and things like that. So then I'm sorry, I'm still mastering this whole thing. All right, so then the next sort of substantive change was in 1997 when a number of offenses were added. That's when murder, manslaughter, certain offenses when the victim is under 18, which includes kidnapping, and that'll become something we'll talk about in a minute. And that is when the act was changed to what it's currently known as. And also what happened in 1996, just to put this sort of in a context, is 1996 was the year that the Kansas Supreme Court decided State v. Myers, which was about retroactive application of the 1994 Act to a person who hadn't been subject to it at the time of his offense, or I think maybe even a sentence, I can't quite remember. And the Kansas Supreme Court at that time said, no, it's not punishment. You can apply it retroactively, except for the public notification part. That part is punishment, and so you can't publicize on the website that he's a registered offender. Well, they didn't have websites back then, you know what I mean? You couldn't, like, go to the sheriff's office and see that he was a registered offender. So then the expansion continues. In 1999, it had been, remember, for like 6 years, a Class A misdemeanor to if you had any core noncompliance. And in 1999, the legislature made that a level 10 non-person felony, which you all know is the lowest level felony that there is. Some offenses increased the registration period to life. Over time, some other things got added, and that brings us to 2006, which is one of the biggest years that we're going to talk about. 2006, 2007, 2011 are the main ones that stick in my mind. So in 2006, also for context, this was the year that the legislature made a huge swath of crimes be life if the person who perpetrated it was 18 or older and the victim was under 14. This was also the year that a whole swath of people were made to have lifetime post release for a large swath of offenses. But also that same year, there were these other changes. And one of them was, well, all right. So there were a couple bills that year, and they had some hearings on the one side about it. And then on the floor, and I'm telling you this detail because I want to show you how, I don't know, one could say little thought really, has completely transformed where we find ourselves today. So at any rate, there were a couple bills going on then, that year. And when one of them was being heard on the House floor, somebody made a motion to change the penalty for all core violations. Now, remember, at this point, there's other kinds of folks that aren't sex offenses that are registering, to make them all be level 5s. Well, you all know, you guys look at the grid all the time. You know that's literally doubling it. Also akin to involuntary manslaughter, akin to robbery, etc. So that was moved on the House, it passed, and that really became the law, because they didn't hear those bills again on the Senate side. So there was never an opportunity to actually address in a hearing, hey, are you sure you want to do that? I wonder if the Sentencing Commission even got to do an impact on that, quite honestly. So another thing that happened in 2006 is the legislature passed a special rule, I think it's 30 something, that makes every CORA conviction presumptive prison. And finally, it also expands people from other states. Another thing that happened. Sorry, I'm also looking at my notes because I did this thing like when I was listening to Judge Huffman, I was like frantically writing things down that I want to tell you. So also in 2006, if that wasn't big enough, 2006 was also the time that we saw the addition of a new category to the definition of offender, and that is people convicted of a person felony when a deadly weapon was used in the commission. I, to this day, cannot tell you whose idea that was. It was not any of us that were at the hearing. This was another thing where we had a hearing. It was me, 2 proponents of this bill, and they're like, what are you talking about? We didn't ask for this. I'm like, well, it's in this bill. And so to this day, I cannot tell you how we came to have this category of people that I believe makes up the largest portion of violent offenders in this state. That was another one that was not heard on the other side. So I justified House Fed State. It's like, okay, well, surely this won't go anywhere. And here we are. And so, as you know, person felonies include aggravated battery, aggravated assault. And so this is a part of the, CORA where the judge makes a finding that a deadly weapon was used. It's not a list of offenses like some of the other, definition sections. So, and honestly, over my time, I've seen all kinds of things be deemed a deadly weapon. I lost a case where they said a taser was a deadly weapon. Even though, its express purpose is the opposite. So I've lost that. I had a case where a bowling ball was a deadly weapon. Of course, steak knives, all kinds of things. It's not just guns. It's not even just things that we would normally think of as weapons. So also in 2006, was the $20 quarterly fee added. And while I'm just on the topic of the $20 fee, I'm just gonna keep talking about it, even though it takes us a little bit out of the timeline. So that's when the $20 fee was required. So every time you go as part of your quarterly reporting, you have to pay $20. Then in 2013, there was a request to add a specific penalty because people didn't want to have to charge folks with a level 5 or 6 for failing to pay their $20. They wanted to have a special penalty that was less than that. And they made it a strict liability offense. They made it a Class A misdemeanor if you don't pay your $20 first time, and a severity level 9 felony if you don't pay more than that one time. So, yeah. Then you can get a waiver. The statute allows, if you were, for example, represented by a public defender, so there was an indigency finding made in the last 3 years, then you can use that waiver to get the $20 fee waived. But there's no statutory mechanism to try and get that $20 waived beyond that or any other situation. And so in 2018, the Kansas Court of Appeals found that that was a due process problem with regard to Mr. Owens, because he didn't have a mechanism by which to have that waived. And to this day, Owens has not been addressed by the legislature. And so I think there's a number of places, maybe all places, I don't know, that have stopped charging people with that. Okay, so 2007 is another big year for CORA. That is when we added a drug offender registry. Now, I know that Judge Huckman was talking about, oh wait, sorry. I forgot to tell you that as to the $20 fee, I've never been able to find any other statute that makes it a crime to not pay a fee. Just that one. Okay, sorry. So back to 2011, Judge Huffman was talking about drug registries. I've never found a drug registry that looks anything like ours. Never heard of one, never seen one. Nobody's duplicated ours, as far as I know, etc. That bill started out with just having people convicted of manufacturing be registered. And then a constituent said, well, you're more likely to live next to a drug dealer, so we should include distributions as well. And the KBI actually came out against that, concerned about that, saying that that was going to put a strain on the registry. And, asked the legislature, press pause on that one. But in the end, it covered all possession with, regardless of the amount. If you were convicted of possession with intent to sell, which we now know is distribution, or manufacturing or possession of precursors, then you were by statute required to register. Unfortunately, that statute did not have a start date. And so, for 6 years, they applied it retroactively to people who had been convicted of drug offenses when there was no drug registry. They had no idea there was ever going to be a drug registry, etc. And it also included federal and out-of-state drug convictions. There's no federal drug registry. There's no federal drug conviction requirement to register. It's only imposed by CORA. In 2011 is this is the final huge sweeping thing I want to talk about. And that is as Judge Huffman was talking about earlier, when states were wanting to become in compliance with SORNA. And to this date, as Scott pointed out earlier, there are only 18 states who are SORNA compliant. For various reasons, policy reasons, cost reasons. The other states are like, no, thank you. We'll go ahead and take the hit of our 10% of our burn grant money, which we're going to talk about that in a minute too. But at any rate, so the KBI led this working group that came up with this proposal to the legislature. And they had a lot of things in there that exceeded the SORNA requirements. And also, let's remember, SORNA has nothing to do with drug offenders nor violent offenders. It only has to do with sex offenses and kidnapping of a child or something. There's a couple of violent offenses, but other than that, SORNA literally has nothing to do with the drug registry or violent offenses. And so that sweeping proposal passed, and it shortened the amount of time that you had to report changes, 3 business days. It changed the penalty scheme so that your first time was a 6, your second time was a 5, and your third time was a level 3, or if you had been out of compliance for 180 days. So, for example, case I heard about the other day, somebody didn't know he was supposed to give his Facebook account. And so now he's looking at 9 charges of a level 3. So as though he had committed 3 ag robs or just not told them his Facebook address. So that remains the penalty structure to this day. The 2011 changes also expanded what had to be reported. There's now 21 different categories. If you look in the statute, there's 21 different categories that a person has to provide information about. Yeah. More grants. And I guess, you know, I've already said this twice, but I really want to drive it home, which is that coming into compliance with SORNA did not require us to treat everybody the same, and that's exactly what happened. So whenever we talk about this penalty or what's required of people, all those things, it applies to every kind of offender, every kind of registrant, regardless of what they registered for or how long they registered, etc. By the way, and this will become important here in a minute, but as Judge Huffman was saying, Kansas was, if they hadn't been SORNA compliant, were facing a loss of 10% of their burn grant money, which I think she said was $230,000. I know our award, our more recent awards were more like 10% would be $240,000, and that'll become important here in a minute. The other thing that I was struck with, what Judge Huffman was saying today, I was at those hearings where the KPI working group rolled out this giant proposal, and I testified and I listened and everything. And not that year, not 2006, not 2007, did anybody ever come in with any evidence that says, we have to do this because we know it's going to help? Like, there's no evidence. There was no evidence presented that this was going to improve public safety or reduce recidivism. I have yet to see any of that kind of evidence presented in a hearing in the last 19 years. 2012, there were some other changes. And then in 2013, the drug offender category was changed so that it just applied to convictions on or after the date that that definition became law. I don't remember who proposed that. Was that a sentencing commission thing? I don't know. I just can't remember. Okay, but speaking of sentencing commission,
Yeah,
In-
it's not a sentencing commission.
the 2013 one? Okay, so, I mean, this seems like a good time to, I'm gonna state another thing that's obvious, which is that the sentencing commission has long been advocating, like, seeing the problems with the registry and not only the impact that has on, you know, people in prison beds, but also the impact it has on people being able to do the things that we know are best practice. And so I obviously, longtime fan of the Sentencing Commission, but I just want to give a shout out that this body of people has been working on this issue for a long time, and you have had successes with it, which leads me to 2016. It used to be, from 2006 to 2016, all quorum violations, not only were there 6, 5, or 3, they were also all person felonies. So even if you were for a drug offense, which was non-person, your quorum non-compliance was a person felony. So in 2016, the Sentencing Commission asked the legislature to have the non-compliance correspond to the type of offense that a person registers for. And so that's why now it is that drug registrants, when they have non-compliance, it's a non-person. So that, anyway, I just want you to know that you all have been working on this a long time. I see that, and you have had successes around it. Geez. Okay. 2017, 2021. So 2022 would be the only other sort of big thing to talk about. And I don't know if Representative Owens is on the Zoom, but in 2022, the legislature passed an exit mechanism for people who register for drug offenses. And that was kudos to Representative Owens for having that hearing and making that become a reality. This stems from a suggestion that was made by a Judicial Council subcommittee, and that's another thing that's in your packets, are the recommendations that that subcommittee that Judge Sexton, also a big fan of Judge Sexton, I know he's on there, that he was the chair of that. And so for over 2 years, we worked with a large number of stakeholders to come up with some suggestions. And one of those was an exit mechanism that would be open to all registrants. But this was a great start. And so I've actually been to some expungement clinics for people that are trying to get off the drug registry. In fact, the first one I went to, the first guy sit at my table, he should have never registered because his conviction was before July 1, 2007. So at any rate, so I don't know the numbers of who all's been found success with that, but it's a huge step in the right direction to have that exit mechanism. I think that I kind of already touched on this. So the how of how we came to have some of these things is honestly one of the things that gets me the most. You know, it'd be one thing if things like doubling the punishment had been vetted on 2 sides and people had gotten to talk about it, or even vetted on 1 side at a hearing, or if we'd been able to talk in 2006 more about add that whole new category of violent offenders. But the fact is that we have these giant changes that have come about because of a conference committee or a House vote, and they weren't actually, discussed and really that's the thing that gets me. And so I think it's important also to note that, and I was thinking about this when Judge Huffman again was talking, that, I don't see a lot of moral panic. It's just more like, no will to do anything. And so, anyway, it's frustrating because that's the thing. You would think that in these instances, you might be able to go back in the legislative record and see comments that people have made about, this is why we're doing it, this is why I'm voting for it, and that is just not there. Again, like I said, I can't even tell you why we have the category of any person felony with any deadly weapon. And I know that this is a little bit off the topic, but I just do want you to know that juvenile registration is still a thing. And there is some discretion if the child is under 14 when they commit an offense. There's some discretion if they're 14 and it's certain other offenses. But if you're a child who's 14, 15, 16, 17, and you commit an offense that would be an off-grid or a level 1 if you were an adult, then you register till the day you die, and there's no exit mechanism. So, just to kind of give a little sum up. When the act first passed, this is the number of offenses it covered. You had to register for 10 years. Today, the left-hand side is all offenses that are registerable, and the right-hand side is the length of time. This is just me screen grabbing the journal entry form from the Sentencing Commission. It's in your materials. It's obviously available at any time on the legislature or on the Sentencing Commission's website. Back when it started, you had to give where you lived to the sheriff. Now, these are the things you have to initial every time you go in for your quarterly visits. I also discovered yesterday that if you ever want to see what it is that people are supposed to fill out at least 4 times a year, it's all on the Sentencing Commission's website. So you can actually see the small print, you can see all the instructions, you can see that they want you to tell you the general parking locations of your car, etc. And so if you ever want to check out that, it's on the Sentencing Commission's website. Just roughly speaking, the duties that registrants have include, like we've been talking about, these quarterly visits. If they decide that you're transient, then they can make you come report every 30 days or even more often than that. You have to register where you go to work, school, and where you live. And I think he left, but we were talking to,
Yeah, that's right.
oh, right here. Oh, you're right there. We were talking about, I'm about to talk about you, sorry, but we were talking at lunch about how, so he's got to go register where he works, which is a different county than where he goes to school. Where he goes to school is a different state. And keep in mind that it's not like you can, in a lot of counties, you have to make an appointment. In a lot of counties, you can only go this 2 hours on this day or this 2 hours on this other day.
That is true. I do have to have a pass when I go to UMKC, to get my bachelor's degree. I have to let them know when I enter Missouri. I have to let them know how long my classes are, and then I have to let them know when I leave Missouri to come back to Kansas, and I have to do that for 2 years for as long as I'm in school, because I have to not only oblige by Kansas laws when I register, but now I have to oblige by Missouri laws just for going to school day.
As I said, there's 21 category. Thank you for talking and letting me talk about you, by the way.
That's what I'm here for.
Okay. Like I said, there's 21 categories of information that registrants have to turn over. When those things change, you have to report that. So if you get a new email address, you get a new car, you gotta go in sooner, let them know that. The lengths of registration are now 15, 25 of life. You're required to renew your driver's license annually. We've already talked about how there's a special rule that makes every non-compliance presumptive prison. And the other thing I like to point out is that Cora has a long list of obligations that other entities have. So like the sheriff or the KBI or the prison or the hospital, things like that. But there is no penalty, no consequence if any of those other participants in Cora fail to do any of their duties. The only person that faces a consequence and a high level criminal consequence of that is the person with the registration requirement.
What do you mean by that?
What I mean is, so one of the things we're gonna talk about in a minute is a case that where the sheriff had an obligation to tell somebody, this is when you need to register or whatever. And the sheriff didn't do that, and the person, so the registrant didn't do the thing they're supposed to do. And so that was the defense that they made. And the appellate court's like, yeah, no, it doesn't matter. You have a duty to register. It doesn't matter if that person didn't follow their duty by telling you X, Y, and Z. And so it's still on you. Oh, so then of course this is very important. Back for the first several years of our Offender Registration Act, there was an exit mechanism. And it did cover, because of course for a long time it just mostly covered folks convicted of sex offenses. But for a long time, there was a way that you could actually petition to have yourself removed from the registry. And today, no, you can't do that. And not only can you, unless you apply as a drug offender. So no person can ask to be relieved from the registration early, except for drug offenders. And this includes people who, if they came to Kansas and they had an out-of-state conviction, and they didn't have to register anymore in their other state, or maybe they never had to register in another state, such as drug offenders or certain violent offenders, then you'd still have to register in Kansas and you could never get off of it early. And also another thing that still exists is, of course, that you can't get any of your convictions expunged as long as you register. And this is any of your convictions, not just the thing you register for. So if you register for, I don't know, a drug offense, and you register for, or sorry, you register for a drug offense, but your prior convictions are for a drug offense and a theft, you cannot get that theft expunged until you are off the registry. And this is one of the many things that working group asked for, that certainly was not required by SORNA. Okay, let me look at my notes, which I kept forgetting existed. Oh, one thing I forgot to tell you. If you, the current periods of registration are 15 years, 25 years, and life, depending on what the offense is. If you get a second qualifying conviction, then you register till the day you die. So, and that includes drug offenses. So, for example, I've had a guy, he gets 2 different drug cases within a short span of, like, convictions and sentences in a short span of each other, for whatever, let's call it level 4. I think it was like level 4, level 3 drug possession with intent to distribute. And now he has to register for life because there's 2 of them. So it's second or subsequent of any kind, any combination, they register for life. All right, so just to look at the case law, I already talked to you a little bit about Myers and how that was the first case that talked about how the 1994 version of the Offender Registration Act, they said it was not punishment, and so they could apply it retroactively. And the only part that is punishment was making the person's information publicly accessible. Then we fast forward quite a bit, and there's a US Supreme Court case that it's now 21 years old, where the US Supreme Court found that Alaska's version of the Offender Registration Act was not punitive. Interestingly, number one, their state Supreme Court later found that it was an ex post facto violation under their state constitution. Number two, Kansas doesn't have an ex post facto clause in our state constitution. And number three, the CORA of 2011, for example, and the CORA of today are nothing like Alaska's version. And I have a chart for that, but I didn't burden you guys with it. But that case is what was used, and we're gonna get to it here in a minute, but that was the case that was used in 2021, in 2016 to uphold our act. Oh no, what have I done? 2016, okay, right. So on this April 22nd, 2016, I was like retired from being a public defender, but I was reading the cases and I was like, oh my gosh, they found that CORA is unconstitutional, or they found that you can't apply it retroactively because it functions as punishment. And I was like, over the moon, I've been fighting this for 10 years. But then I just had to read the next case to see that in the same day, the Kansas Supreme Court overruled itself and said that CORA was not punishment and you could apply it retroactively. So all of that happened in the same day. So Peterson Beard is the case that to this day, is the reason why we apply, core obligations, core requirements, et cetera, to people, even if those did not exist at the time of their offense or their sentence. We took another try at it in Davidson and in state VNR and had no luck. NR is actually a case about a child. He was adjudicated as a juvenile. He was 1 month from finishing his 5 years of registration. And then the 2011 overhaul went to effect. And then, so then he had to register till the day he dies. And the Kansas Supreme Court said, that's not punishment. He doesn't violate due process, etc. We've had cases that tell us that, that core is not punishment with regard to drug registrants or violent registrants, and that for them to, they have to show through the clearest proof that something's punitive. And I've never seen a case like that. I don't know that I've ever even seen anybody try. Then we have a couple of cases that tell us that registration is not part of your sentence. And it's so not part of your sentence that if your notice of appeal says you're appealing your sentence, they won't consider your court issues. Even though it's on your sentencing ruling. It often is imposed at sentencing. But at any rate, so we have those cases telling us CORA is not part of your or part of your sentence. And yeah. And then this I throw in, not because you all deal with municipal court convictions, but I throw this in because it's going to help me make my point here in a little bit later. So back in 2012, there was another bill that was going to make some further changes to CORA. And one of the things that the working group, I think it was still the working group, asked for was we wanted to apply to municipal convictions. And remember, municipal courts are not courts of law. A lot of times people don't even have lawyers. And so I testified against that and said, hey, don't do that. And the bill even said it, right? So in the end, they struck that language from the bill. They made some other changes, but they took that part out. So this gentleman got convicted in municipal court. He argued that municipal court convictions for sexual battery aren't covered by FLORA. And the Kansas Supreme Court said, oh yeah, they are. And there was a dissent where Justice Standridge pointed out my written testimony. But anyway, that's gonna make a point here in a minute. And this is just a side note. It is in fact in the Code of Criminal Procedure. One of the arguments of one of the things that the court said was, well, CORA is a civil penalty in a sea of criminal something or other. And really, no, it's always been in the Code of Criminal Procedure. Another thing I want you to know is that there are no defenses to CORA violations. I mean, of course, you can argue things like, no, I really did live at that house, or no, that isn't my car, things like that. But if you have things like my apartment burned down and so I didn't register on time, or I got a new jet ski and I forgot, or whatever, those are actual real cases. There are no defenses. It doesn't matter if somebody didn't fulfill their obligation to you to tell you something you need to do under the act. It doesn't matter if it doesn't matter. So one of the argument stole is that if this is a civil regulatory scheme, then substantial compliance, usually suffices. And they're like, no, it's no defense. And also another thing that happened in 2010 is the legislature made CORA non-compliance a strict liability offense. It is the only felony. That list of things that in the statute that are explicitly listed to be strict liability offenses is very short, and the only felony among them is CORA non-compliance. And the last case on this list the argument was this person was literally having a psychotic episode, so he didn't register on time. And one of the other arguments, that's sort of the facts behind it, but one of the arguments was you can't, it can't be okay to have something so severe be a strict liability offense. And the Kansas Supreme Court said, no, it's fine. And so all right, so this is the part where you're just like, okay, so why are we talking about this at a sentencing commission workshop if it's not part of your sentence? It's a civil regulatory scheme. And I would suggest, well, there's a lot of reasons, but let's start with the one that comes from your own dashboard. That this core non-compliance from the civil regulatory scheme is in the top 10 offenses that people are convicted of. It's in the top 5 sentencing rules that is applied to people, the special rule that says all 4 convictions are left to prison. It is because the penalties are so high. And so here we have this scheme that has been deemed, I can't read it. What is it? A tangled, jumbled, and brain knot is the way that Kansas Supreme Court justices have described Cora. And that yet we are going to have people who are not legally trained, who aren't justices, be subject to these penalties when they fail to comply. Another reason that it's important that you all are talking about this is the kinds of things that Judge Huffman was talking about. And the kinds of things that I've heard this body and others talk about, which are like, what are the best practices? Best practices are things like be evidence-based, give people incentive to do well on supervision. And that includes, early release if they do everything they're supposed to. You want people to be involved in pro-social activities. You want people to work, all of these kinds of things. And this is just an excerpt from the NR case, which is that kid, who's not a kid now. And he was talking about, this is the impact that registration has had on my life. And those things run contrary to, I would say, in my opinion, run contrary to public safety, to pro-social behavior, to best practices, to research-based solutions, etc. And again, to echo what Judge Huffman said, I've not ever been in a hearing where somebody brought evidence that registration improves public safety. I have been to hearings where I've heard the opposite, and I'll get to that in a second. But, and this is like one of the things is about recidivism. And that he recidivated and used drugs because of the stress and the inability to get into treatment facilities, etc. I had a guy one time who was charged with forgery, and when I was reading his police reports, he said, I wrote that check because I needed $20 to register. People miss work to register. Another thing that I forgot to include on any of these slides is that there's also a presumption in child custody cases that has to do with if one of the parents is a registrant. Another reason why it's great that you're talking about this is if this is about recidivism, then Cora is not addressing it. Because when you make the registry over broad, then you're not actually communicating anything of any value to the public. This is what I want to tell you. So, I've never heard any evidence that it helps public safety. So in 2018, it was, I think, the Sentencing Commission bill, and it was about removing people from the drug registry, or getting rid of the drug registry. And so one of the people on the committee asked the DOC to do some research to see what's the recidivism for people who are registered as drug offenders versus the DSC overall. Now, this is in 2018, so I don't know what it is now. But and you can find this on the legislative website. So the overall recidivism rate in 36 months, like people coming back to DSC, For people, just overall, 35.97%. And people who were drug registrants, it was 37%. So if the argument is that somehow they're being on a drug registry decreases recidivism, that's not how it played out. And it's no surprise that that's not how it played out, if this is the sort of thing that you're seeing or experiencing, or that people have to deal with. And the other thing, of course, that sort of ties into this, how does the registry doesn't actually prevent crimes, is of course that statistic the Judge Huffman gave us today, that 96% of people were not on the registry when they committed the sex offense. So, just to kind of keep hammering on the same thing, that these sorts of things that I've heard this body and the Criminal Justice Reform Task Force and other places say are best practice as far as supervising people, giving them incentives to get off early, doing risk assessments or individualized determinations, things like that. None of that is permitted under Florida. So then I've got some numbers, and actually I'm gonna, don't kind of ignore this because John helped me out and John got me some numbers. And so, well, let me tell you this. So, you know, there's gotta be over 20,000 people now who are registered offenders. And they are broken, you know, into categories. But what John got for me, out of the 4 big counties, there are 4,008 people who register in Sedgwick County, and the other 3 big counties, Johnson, Shawnee, and Wyandotte, the other 3 combined register 4,363. And we're going to see here in a minute, the bulk of convictions in fiscal year 23 for core noncompliance were from Sedgwick County. Now, again, I'm bringing all of this up because this is why it's so great that you are talking about this thing that is the so-called civil regulatory scheme, because it clearly has an impact on making, it actually could increase, you know, is increasing recidivism, or could increase recidivism, or lead to things that we know are bad for public safety. And also it's filling your prison beds. And so that is why I think, that's why I'm so glad that the Sentencing Commission has had this commitment to addressing this, even though it's a civil regulatory scheme. But at any rate, so one thing I think about a lot is that whole, we don't, you know, we're trying to keep the 10% of our burn grant money. And as I said, back in 2011, it was, I think as Judge Huffman said, let's call it $230,000 is what we stood to lose if we didn't become SORNA compliant. And last year, I think it's more like 10% would have been 240,000. And I got guys doing time in prison that exceeds that amount of money. So you, if like one of my guys hadn't been sent to prison, you'd have $240,000. You'd have $350,000. And so this idea that we could lose $240,000, there are some solutions that you all have started to identify that would give you that money back. And so, again, this is where you can see how bad my slides are, where I just grab the screen, grabs, whatever. But for 1 year, I came up with over $9 million to pay for everybody to be in prison for 1 year. They got sent to prison for core noncompliance in 2023. Now, one thing to keep in mind is these folks, for the most part, because I see cases from across the state, these folks are not like being charged with something else too. Almost always, the only thing these folks are charged with are core noncompliance, and they're going to prison for core noncompliance, not for something else as well. Oh. Yeah. one of the, I just feel compelled to say that, not only are there all these people in prison, for poor non-compliance, but a couple weeks ago, a guy was doing a sentence for 18 months solely for poor non-compliance, died while he was in prison. So, this is having a real cost in, lives and money. So another reason why you all, I'm glad you're doing something about this, is because the only way we can, try and modify any of these things is clearly not gonna come from the courts. And that's kind of one of the reasons I gave you the example of the municipal court case. It's literally struck from the bill, and the Kansas Supreme Court says, no, it's cool. And so it is clear to me that we are not going to, the courts aren't going to help us roll this back, that the only entity that can help is the legislature. And in a way that makes sense, since they are the ones who created this. And I can make arguments all day long, and I do, about how much this costs. And the Court of Appeals, and I understand, keeps telling me over and over again, that's an argument for the legislature. And so I'm glad that this body is taking this up once again, because this is an argument for the legislature, and it's something that only the legislature can fix. The other thing I meant to make a point of in this slide is that it is extremely common for people to do more time in prison for core non-compliance than the thing they register for. Very common. And I think the most I've gotten to is a guy who's doing 12 times longer in prison than what he would have served for the thing he registers for. It also, of course, includes people who register for sex battery, which is a misdemeanor. Their non-compliance is a level 6, 5, or 3. So those folks are definitely serving more time in prison than the thing that they registered for. So I know I'm almost out of time. And, but I did just kind of, this is in your materials too. But here's sort of a look at the last 7, 8 years of things that have been proposed by the Sentencing Commission or others. The things at the bottom have been proposed by the Judicial Council Subcommittee on Sex Offenses and Registration. Half of the time, there have been hearings. And I did go back and read all of that testimony last night. And the people, the only entities in those 4 times that there were hearings, in those examples there, the only opponents are sheriffs, chiefs of police, or peace officer organizations. And some of the comments that they make are things like, well, this would swing the pendulum too far the other direction. Or our members believe that this info is what people need. Or we believe the registry is a proactive means to protect the community, things like that. The thing I would say about the whole pendulum swinging, and something to keep in mind when you all are having these conversations and making your plans, is again to remind you of that we can't even tell why we have a category of people who register as violent offenders. We can't, there was no explanation for why we would double the penalty. So this idea that the pendulum would be swinging back so far, well, I don't know why it's swung in the first place. And so I just, I understand the concerns that people make. I listened to what Judge Huffman had to say, but I do believe that there's some ground that you all could find. So I'm just looking at my notes again. Sorry, I've worn myself out apparently. Yeah. So again, I think that you have a lot of great examples that you all have come up with in the past in your own bills. In your packet, there are the recommendations that the subcommittee made that we have had be part of 2 different bills in 2021 and 2022 and 2023, sorry, 3 different ones. And so that could hopefully give you some things to start with, and I will say that when I was rereading that opponent testimony last night, that there were times where the opponent said, okay, we can get that maybe we need to dial down the penalties. And we can get that maybe we need to have people just register where they live, not all the other places. And so I believe that there is some room, to hopefully come to some agreement with folks about ways that we can roll this back a little bit. So, I don't know if anybody has any questions or comments. I don't know if that's even what you wanted to hear. Yes,
Well, two things. One, how if the subsidy commission came up with some bills, how do we get it where we have, are just having a hearing on one side or just maybe in a committee like they did it to, you know.
so, right. I mean, the thing is that, you know, I talked earlier about how Representative Owens, I mean, I believe that's why we have an accident. I know that's why we have an accident. You know, Representative Jennings, he tried really, really hard. And so what I've come to see is that it's not just folks who are the chairs of things, although they have been champions for trying to modify this act. And, you know, we have legislators on our subcommittee and things like that. But what I've also come to sort of realize, I'm not like savvy legislator, I'm just like the person that knows the law or whatever. But I realized that I guess we have to get leadership, people that set agendas and decide how time's gonna be spent to like see these points that we wanna make and why we need to make these changes. And that's just my unsavvy part talking, but I guess I picked up enough in the last 20 years to realize that those are folks you have to, you know, get interested in and convince them that this is worth time and discussion too. Is that what you're asking?
That is exactly what I said. Also, when you're looking at the legislative discussions, is the $20 sticking point for these?
Oh, yeah. Well, one year was, so back in 2018, that bill was, 2018, I think it was. It was contentious, I noticed that the DA County Attorney Association was like, that's cool, you know, change the penalty for not paying $20. But that, at least the sheriff of Sedgwick County was like, we can't do that. And the thing that, again, I can't find any other statute that makes it a crime to not pay a fee, especially a fee that's for a civil regulatory scheme. But it's funny because people use language in 2013, the language that they used to get the $20 fee and some of the language that they use since, it's like they didn't get the memo that this isn't punishment. Because they talk about the fee as, you know, they use very punishment-y words sometimes. But yeah, but that was, again, that's 2018. So if you ask folks now, well, how do you feel about it being a felony to pay $20? Maybe they have a different position, because again, when I went back and looked through the testimony, the opponent testimony of these bills, especially the ones from the Judicial Council Subcommittee, there's rooms where we were going to be able to agree. It didn't advance beyond the committee. No time any questions. Sorry, I'm kind of spazzy. I mean, I could literally talk about forever and ever, which you should be glad that I'm not going to, but my contact information is at the end. If you want to email me, I have lots of, I've got legislative history, I've got all kinds of stuff. So if you have any other questions about how we got here, what sort of comments might have been made in getting here, or just questions about how it works, I encourage folks to contact me.
Thank you, Jim. All right. 15-minute break.
That's break on that.
Yeah, I think we're good. All right, you ready? Good. Okay, welcome back, everybody. We're gonna kind of start pivoting, at least anyway, away from offender registration and now look at another topic that was discussed by the legislative committee of the commission, and that is program credit. Thankfully, we have experts with us today from the Kansas Department of Corrections to be able to fill us in more on rudimentary things even, as to even what is program credit, which, you know, most of us kind of take that for granted but I kind of wanted to get to let's start with the baseline and work our way up. And there's also some, I think some really good lessons to be able to learn from the folks that are actually working in that space. And so with that, we have two members from Department of Corrections, one former member who's with the Department of Administration right now. Just wanted to all, we're just going to kind of do a panel discussion again this go round but just starting off, maybe start with name, position, and what you do for the Department of Corrections.
So my name is Melissa Waldock, and I do classification and population management for the state. To kind of sum it up, we're making sure that people have the correct custodies, that we've got bed space for everyone, and we're deciding where to put them, that we work with the unit team and the classification administrators at each facility to ensure people are getting put in the right programs and they're being given the right tools.
Hi, I'm Mary Stafford. Good afternoon. I'm the Director of Victim Services for the Kansas Department of Corrections. I've been with the department now just over 5 years, and in this role, I just celebrated my first anniversary a few weeks ago. And so when this opportunity came knocking, I quickly grabbed my predecessor, Audrey Press, to say, help, let's do this together, right? I know just enough to know what I don't know. And so a little bit about our work in victim services. I think it's a little bit more abstract for folks who are less versed in what we're doing. But we're both providing services to victims post-incarceration. So people who have been harmed by someone under the supervision of Kansas Department of Corrections, either in facility or on parole. And then we also offer restorative programming in which victims have a voice in how services unfold and what justice looks like in their purview. And then we also do offender programming, resident offender programming that's victim-centered for folks who have caused harm as well. And so that's a little bit about what I do, and I punt it over here to my predecessor.
I'm Audrey Kress. I'm the statewide recruitment manager for the Department of Administration, but formerly spent 10 years as director of victim services. And anytime Mary invites me to come somewhere, I'm in. So excited to get to be in this space with all of you. One thing that I'll add just for a little bit of context, Kansas, most states across the country, the Victim Services Division handles the statutorily required victim notification. So in most states, that is 1 or 2 or 3 people that are just sending out updates about that public information of status changes. Turns out when you send out public notification of status changes, people have questions, and most states go, check the website. And so we're excited in Kansas to have really proportionally one of the largest victim services division in the country. So Mary didn't blow enough up about the amazing work that's happening. And now stepping out of that role, I can say it's pretty incredible what Kansas has to offer for victims. So excited to bring us here to be able to talk about the great work that's happening. And I think just the fact that you all are asking questions about the impact for victims says a lot about the work that's happening in Kansas.
So just to play on that a little bit, you talked about status notifications. What is that? What kind of, is it change in status? What are the examples of that so that we have some idea?
So I will start and you for sure piggyback. So there's roughly 25 qualifying events that would prompt a notification to be sent to a victim. Some of those are in statute. Approximately half of those are in statute. So those are things like someone's coming up for parole and the victim has an opportunity to participate in public comments. An offender has died, right? A resident or an offender has died. There's, yes, someone's classification, maybe they've been switched to minimum custody, and so now maybe they're eligible to obtain employment off campus and those kinds of things. Then we have some that have just been identified as KDOC policy as best practice. And so there is also notification we do just because it's the right thing to do.
There's things such as that we're involved in, if somebody has applied for early discharge, we're required to notify victim services, so they can notify the victims of that. Or if somebody has applied for clemency, they have 30 days notice to notify the victims of that, and those things that we're involved in, as a person review board, that we're required to let the victims know certain changes of those statuses as well.
The PRB the Prisoner Review Board are very close allies of victim services, and so Mark, we have an open chair. At any point you. Love to
Thanks,
hear
appreciate it.
And just for some context, we have 44,000 registered victims through the Office of Victim Services. And we provided notification to almost 20,000 last year.
And I just want to note that that is if they register with victim services, which does not always happen. So it's really key for, I think it falls on the prosecutor's offices to actually connect them with victim services so they actually get registered and get the notification, because so many times there's an assumption that they just know. And they don't always do that. So that's something that we are working on to make sure that prosecutor's office are actually doing that handoff from the criminal case to victim services so that they receive those notifications in a timely manner. And it's not not automatic.
Excellent point. Thank you for adding.
Very good. Well, let's back things up a little bit, and just talk about just a fundamental, what is program credit and everything that goes along with it. I know that's a broad question, but Melissa, can you kind of start us off with maybe defining what that is and what its purpose for the system?
So program credit is basically a pool of credits. Right now it's 120 days. And that amount, it allows them to complete a program such as GED or another class that's approved by the warden. And then they get that time. So they can earn those 120 days off of their incarceration time. So the amount of time that they're actually spending in prison. That amount then gets added to the back end of their sentence so that they're spending that more time on parole as opposed to having them be incarcerated. A big part of that is one, it creates more space for us, and in our prison, unfortunately, but it also allows that person to get out that much sooner and start back those community ties, which is super important. Depending on where they're going, we want to make sure that we keep them in the community as much as possible, because you don't really want to break that. The more it's broken, the harder it is for that guy to reassimilate back into the community. So, and of course, when you're dealing with that program credit, they see, okay, I get out 4 months earlier, but it isn't a freebie. It's just that pool of credits gets added onto the end. If they act out, if they have behavior that is unacceptable and they end up getting disciplinary reports, that pool of credits gets added into their good time. So it is eligible to be forfeited at that time if needed. That is extremely rare that we forfeit that time. In fact, I can't even think of a single time that we've actually had to do it. Usually when those guys earn that program credit, they're so happy to have earned it that they can move forward.
So you're differentiating now between program credit and good time credit. Can you kind of tell us the difference between the two?
Yeah, so on your basic sentence, you get, when they go to the judge and they get sentenced, they get a certain percentage of good time, depending on what the law has allowed. The program credit, they have to specifically do a program that is eligible for these 120 days. And so it's basically a separate pool of numbers from the good time credit. It only gets added into those numbers after they've earned it. So just like anytime you earn good time on a sentence, that time kind of gets put onto that back end. If it gets forfeited or withheld, it's the same with the program credit. So I like to think of the program credit and the good time as two separate entities. You've got your good time over here, your program credit pool over here. This time is going to fluctuate, go up and down depending on behavior. This is a set number that you either earn or you don't earn. And so our goal is to try to get the residents to earn this pool so that they can release earlier than what they had originally thought they were going to release.
So what kind of eligibility then, criteria is applied to whether or not you get program credit? Because there are offenders that are not eligible. What is that eligibility criteria?
So basically the eligibility is, and I see she has the IAPT because it does get very specific as to which ones, which sentences are eligible. So if they are currently under a Senate bill, 479, or 360, they're not eligible for program credit. It's specifically related to the SB 14. Good time SAP. The majority of them are able to earn it. However, depending on their crime, and it has to do with like what level of drug offense it is, for instance, and pardon me for, I keep my notes on my phone, but so if you've got a guy that had an indeterminate sentence and a determinate sentence, they could possibly earn good time on that determinate sentence depending on when it was, but they're not going to earn any on that indeterminate sentence. So our sentence comp unit reviews everybody and they determine who is eligible based off the set of guidelines that is allowed. They also, we'd like for them to have 6 months remaining before they release so that we've got time to work with them on their residence plan and putting them back in the community. However, occasionally we do make exceptions. If we are able to get somebody through a program, they may not earn all 120 days. They may only earn a portion of that, but we see that as kind of a win-win. Because they're getting some of the help that they need. We're not taking shortcuts with the classes or anything, but they still get to get out a little bit early. And even a week early is a huge motivator for these residents. So that's a really good thing. We don't have any program credit from before 2008, I believe. But so those guys that have been in, guys and gals that have been in for a very long time, like say their symptoms started in the 70s or the 80s, they're not earning program credit because it wasn't retroactive. It was just started at a specific time. And then sex offenders, they do have to complete sex offender programming and a program in order to get that credit. So there's several rules and several safeguards that I would say we employ. And I think that is one to help the victims feel more comfortable, us feel more comfortable, and just make sure the community is safer.
Maybe in the weeds a little bit, but kind of piggybacking
Yeah.
on that, the sentence structure that attaches to the eligibility is one piece. There's also different programs that are eligible and not for program credit. So I'm thinking specifically the programming that happens under the umbrella of victim services. We have some restorative justice programming that we don't offer program credit for because we don't want folks coming into the room to get credit. We want folks coming into the room to be unpacking beliefs around these issues. And so there are some others that are volunteer-led or other things like that that wouldn't be eligible for program credit and are really just about the motivation of the folks inside to attend those programs. So there's great that we have people like Melissa who are following all those statutes and keeping track of all those things, but there are several moving pieces to all of that.
So how is that determined then as to whether or not, and I guess that was going to be my next question as to what are the programs that are eligible for program credit? And it sounds like that there are others then that may not be, may not qualify. What are they and how do you determine whether or not to assess credit to them?
So some of the programs that are eligible for credit would be things like GED. And speaking on GED, if the guy has tried, they've attempted everything they can, if they simply can't pass it for whatever reason, they're still gonna get the credit, as long as they put in the effort to do so. They get credit awarded for doing, substance abuse programming, for thinking for a change. We have a provision in there for work release, if say they are at work release and they've set a financial goal, we'll do that. We've got some case management strategies we can utilize where the caseworker unit team works kind of one-on-one with that resident to set specific goals and action steps. And then they can earn credit for that. They can also earn credit for working a private industry job. So it's another benefit for them to do so. I mean, they're learning a skill. So we want to make sure that we go ahead and utilize that. Any of our vocational education programs qualify. And then we've got some smaller classes that we call 3-packs. And we give credit because they're not a very long class. They get put into these 3-packs that they do, but it's made up of different classes. So it may be made up of some cognitive work, some behavioral work. And then we keep track of when they complete it, when they finish it, and each class that they do. And once they've completed 3 of them, then we can award them the program credit. The wardens have a little bit of discretion to be able to add programs. Like if there's something specific at their facility that isn't offered to everyone, they can go in and do that. And the thing is,
No, I think you've done a wonderful job. Actually. So I'm not fact checking you, Melissa, but I am quite impressed by how much you're going from our policy, right? No, the only thing I would add to that, and Scott, I know that we're going to talk in a bit about the victim impact of program credit, right? What do the victims have to say, or what's the belief or feeling around program credit for residents? But it's, there's nuance around that because our office also facilitates batters intervention programming, which is eligible for program credit. And so in terms of that type of programming, it's really based on conviction, whether there's any past experience with domestic violence, usually arrest, right? I think there has to be arrest. It certainly can be requested later by a parole officer or someone who has concerns. But in terms of program credit and it actually being required by the Prisoner Review Board, there's some kind of conviction around domestic violence. And so in that case, it would be based on the crime of conviction. Additionally, we offer the same programming, same curriculum, in a format we call trauma healing group, which is for folks who are interested in that introspective work, who are looking to identify the traumas and triggers in their lives and to heal from those and move forward and, develop healthy coping mechanisms, but maybe don't have the domestic violence history. In which case they would voluntarily participate in trauma healing group, which is again, not program credit eligible. So there's a balance of basically having programs that folks just want to participate in because they want the content, they're hungry for that information. And then there's stuff that has some different incentives attached to it as well.
and I will say, our caseworkers are invested in trying to make sure that they're putting them in a class that's conducive to their risk level. So what is their, if they don't have any risk factors for substance abuse, it's not going to do someone any good to go through that. So we have to put them in something that is going to be productive for them. A lot of times it's not easy because a lot of these classes require a lot of introspective work and they have to be honest with themselves. So really a lot of credit should be given to when they do earn it. But it does help us, yeah.
I will also say, and I can speak for Veterans Intervention Programming, if someone is unwilling to take accountability and show real introspective progress, they're not granted the credit.
No.
We're not handing out certificates for folks who just show up and fill chairs. There has to be demonstrated behavioral change and some interruption in patterns of thought.
Is there in terms of eligibility, is there sometimes based upon custody classification? So am I able to get program credit if I'm, certainly at a minimum type of setting, but what about a medium or higher?
Yes, you can earn program credit at any custody classification. So we've had some instances where it is harder to earn program credit, say if you're special management status, because there was a decreased amount of programs going on in that area. I would say there's been great strides that every custody is able to earn that program credit no matter what level they are, whether they're special management, max, medium, minimum, they're able to earn it. There's something that they can do.
Do you have, do the offerings vary based upon the facility?
They do. We have ones that are offered everywhere, such as GED and substance abuse, but we have other classes that are very specific to facilities. So I'm trying to think of a good one. Some of the jobs are, depending on what they go into, are going to be specific. But some facilities, you may have a class that's only offered specifically there because it's taught by a local volunteer. And so we didn't have a chance to offer it statewide. Those cases, the warden can approve for that to count for program credit.
Do you have, so these programs obviously are quite varied in nature. And so I'm presuming that, you can't assign for your GED, we're going to give you 120 days to get this done. So it's probably a longer process than that, but you still are only getting a maximum of 120. So there are certain other programs that are going to last much longer than that. But is that what you were talking about in terms of trying to make sure that they're a certain amount of time before they get out so that you can actually have time for programming?
Yes, so ideally, we want to have at least 6 months left because if they get out 4 months earlier, we want to be able to plan for their release. So if they only have 6 months and they're getting out to 4 months earlier, depending on how long that class is, you could have anywhere from 2 months to plan for their release to 5 days. So it's very important that our caseworkers start on that as soon as possible. And they do a really good job, in my opinion, of making sure that we're not just letting somebody out homeless early without any kind of assistance. Speak on what you said a little bit earlier. I was thinking Lansing offers Brothers in Blue. Not every facility has that, but the residents it's a year-long specific program, but they can get program credit for completing when they get done because a portion of it is able to be used for program credit. So yeah, some of these classes are 6 weeks, some of them they're in it for a year. It greatly varies. But I think the one thing that we've tried to keep consistent is not the hardness of it, but the durability and the importance of it. So we tried to make sure that we're not just putting somebody in a class that they may or may not go to for a couple of days, because they're not going to get much out of that. So if they can get something out of it, we're going to go ahead and put them in it.
This morning, we had three formerly justice-involved individuals that provided information to us. Their education ranged through currently as a student in college to a law student that had graduated and is now working for a clerk job for a judge. Can you tell us a little bit about what are the educational opportunities? You mentioned GED, but what other educational opportunities do you have to have in the facilities for folks that want to better themselves?
Yeah, we have GED, we have special education, Title I services available for those that may need extra assistance. But we also have, where they can earn associates, bachelor's and master's degrees. So we have people taking a wide range of classes. I would say the college classes that they do are very good and very important. They really, I think with them opening up with the Pell Grants and stuff, that has really opened it up wider. We had some availability from the colleges, but we've got trades, we have the whole thing now.
And correct me if I'm wrong, Melissa, but I think that's available at every facility in the state. Even if it's just a partnership with the local community
Mhm.
college, providing at least associate's degrees.
Absolutely.
And then I certainly know at some facilities, I'm thinking specifically of Lansing, they have St. Mary's and Donnelly College both come in and provide, you can get your bachelor's degree at Lansing. I can't speak to the other facilities, but I know it's at least possible
Yes.
there.
Yeah, we've got some really good local partnerships with, some of the junior colleges and some of the colleges around the state. And so each facility kind of focuses on, depending on what region that they're in, but it is fantastic. It really is. And it means a lot to those guys to get that education. They're so proud of it. So that is definitely something that we encourage and want them to work towards, and it's only going to help them in the future.
Do they pay for that education themselves?
Most of them, yes. So they typically will either pay for it themselves or they have a grant. Some have scholarships. But there are several residents that end up putting the money that they earn in their private industry job towards the college classes.
Any special program credit then for a person getting their associates or masters or bachelors?
Our program credit is just 120 days across the board.
Gotcha.
Depending on, it's not like master's earns 160 and associate earns 120. It's just one pool of 120 per resident conviction period.
That's per program, correct? Or is that like you get
No.
one program? So you can do 4 programs that were eligible for the credit, but you're only gonna get 120 towards your incentive.
That's correct.
Okay.
Do you get the full 120 as long as you complete one program? It's not like,
Yes.
with the exception of your 3-pack.
Yeah, you will actually get the full 120 days as long as you have enough time left in the facility to earn that 120 days. So regardless of whether it's a 3-pack or it's just substance abuse, that 120 days, if I have that 4 months still left in the facility, I'm earning all of that. It's only a portion of it if my time before I get out of the facility is shorter than that.
Is that statutory that credit's earned, or is that just a facility program? When get this, are they allowed 120 days by statute they complete programs?
Yeah.
Mark has a statute over here.
Do you think, would it be beneficial? I mean, if it's 120, or maybe, you've got someone in there longer, that they could get 30 days for completing batter's intervention, 30 days for a GED, 30 days, so that you keep stacking that up. What Do you think that'd be more beneficial than just a 120 pool?
It would be a great incentive, if you could earn more than 120 days. I would say their motivation would increase. I think because a lot of these guys, that program credit is the motivation to get started, but it's not necessarily the motivation to finish. Because that comes internally as they progress through it. So yeah, that would be wonderful. And the other part of that is you've got guys with varying sentences. So a guy could have, 10 years, and you could have a guy with 6 months left in the facility, and they're both getting that 120 days, but it's gonna mean more. If you're ready to get out and you can see that you're going home than when you feel like, I'm gonna be here for a minute.
How are the number of days earned calculated? Is it a set number per program, or does my question make sense?
It's, so if they have 120 days left before they release, it's just a set 120 days.
No, but how is the amount earned calculated?
You did it or you didn't. Is it all or nothing?
Yeah.
Yes, it's all or nothing. You either earn the credit or you don't earn the credit.
Like for the SAP program, is that, you complete that one program, you get all 120, or is it this program and that program, this program, you get 120?
Yes, so if somebody puts you in substance abuse and you complete the program, you're going to get all 120 days. If you don't complete the program, then you get 0.
We talked about the 3-pack, those are
Yeah, and
short little programs. but
and
you
the
still get
3-pack is
120.
considered, the whole thing would be considered for program credit. Like, if you complete half of it, you're not only getting half the credit. So it's either you earn it or you don't earn it.
So an associate's degree, 120 days, doctoral degree, 120 days.
Right.
Okay.
Or batter's intervention program, that's 27-week program typically, 120 days.
Yep.
3-pack is what, 2 months, and you get 120
Could be,
days.
yeah. Yes,
So
yeah, that
the length of the program varies,
necessarily, yeah,
but still 120 days.
correct.
So
So no matter what, even though like say that batter's intervention and some things victim services has is so much more time intensive, they're still getting the same amount of credit as somebody that is going to class once a week for 6 weeks.
You see people that are unwilling to invest in the longer, more difficult programs if they can take a shorter one. Like, do you think rehabilitatively, it would be better if you could offer them more credit to do the more intensive programs that have more benefit to that individual?
Yes. I do think that some of the more intensive programs, a larger pool of credit would definitely be an incentive for them. But one of the things that we really try to push with them is putting them where they truly need the work. So if that's the one thing that they really should be in, that's what we're going to try to work with the guy on. But yeah, I do think a larger amount of credit for a longer class would be definitely more incentive.
So is the way the credits are awarded, is that a regulation or is that a policy?
The way that they're awarded,
Yeah. Like,
it
stat-
is in
statute,
policy.
statute.
How we do it is in our policy.
Any credit, possible for entering into counseling or therapy voluntarily?
So there are some things that our behavioral health can do, DBT training, that they can work on. So yes, there are some that they can work one-on-one with behavioral health and get the credit for.
Something else I think to note, though, when we talk about program credit and back to the eligibility piece, is there's a huge demand for mental health support, right, within our facilities. There are lots and lots of residents who seek those services, and a finite amount of people who are funded to provide those services. And so then how do you prioritize that, right? Is it the person who only has 120 days remaining, or is it the person who is on suicide watch? And so I think the ethics around that, when you start talking about, kind of the critical, in terms of hierarchy of needs, the things that are essential for the safety and security of a facility, like mental health support. I think the ethics around that get a little bit murky in terms of prioritization and how that is applied.
Well, and I think it was kind of the road we were kind of going down was in terms of looking at, if we're wanting to incentivize offenders, to take that step, with program credit, if we're going to potentially, rather than giving them a finite amount of credit, that allows them to actually work program after program after program, that presumably is going to enhance, their well-being, get them ready for reentry, to actually give them credit after credit after credit based upon the amount of work they're willing to put in. The next question, of course, and this may be a secretary question, is are there resources available to actually to be able to actually fund something like that? That if everybody now feels like I'm not going to just get program credit, I've got it. Plus, I feel like I need to do these, but now I can actually get even more program credit. Are there resources available that could support that type of shift?
I think there's some resources so our capacity is limited, not only by the deliverers of the program, who provide the delivery, but by the space. And so it becomes just a capacity issue. And it's triage, to Mary's point. Who's in a closer proximity to release? They want to be in it. Let's get them in first before the other guy. And you hear that from the population a lot, particularly the population that's doing a lot of time, is they don't often get an opportunity to get in some programs because they're so far away from a release date. So the short answer is we have some capacity today and we're hoping to continue to grow that capacity. And then I add one thing, when I'm out and about walking in the facilities and talking to our population, in the top 5 things they talk to me about increasing the program credit and increasing good time. They are highly motivated by those, and I appreciate the comment that that might be the motivator to get them in initially, but once they get in and they kind of have some success and they see that it's changing them and it's beneficial to them, then I think that's what carries them through to the end. I think Melissa was exactly right on that. So anything to incentivize their doing good things while they're there is good for them. It's good public safety as they get out. And then just from a management perspective in our prison system, it's good for management. It's giving them something to occupy their day, something productive, rather than just sitting around and thinking about maybe other things that they could be involved in.
Have you had occasion to, as far as these programs we've talked about, measure the effectiveness of the programs? That would be,
I'm so glad you asked. Do you mind if I jump in?
Go for it.
Just speaking to demand versus capacity, I did pull some numbers, because, we manage and facilitate the battered intervention program. Last year, we had almost 400 referrals from parole officers, for offenders on parole to complete the program. And we were able to serve 180 of those, which is just under 50%, just strictly based on capacity, just number of folks that we have to do that work and to do it responsibly. It is not ethical or responsible to fill a group with 50 participants when you're talking about meaningful, impactful, introspective work. The average group size is closer to 10 to 12. And so yes, there's demand. There's people who want this program or programming in general. And, a plug for support it, as best we can. Back to the question. Jog my memory. What was your, I went off on my tangent.
effectiveness.
Effectiveness, thank you. We do study the recidivism for batterers intervention program. And it's after 5 years, 85% of folks who completed batterers intervention program through the Kansas Department of Corrections, 85% did not have another domestic violence charge within 5 years of their completion of the program. I can just speak to BIP on that. I also, anecdotally, I don't know if Melissa has stats, but I can anecdotally tell you that they're impactful and they work. I'm sure other folks have things they could share to that.
Yeah, so the other person that was supposed to be here today actually has those statistics, and we'll get them for you all so that we can get it distributed. But we definitely have more demand for the programs than we're able to put through. We are putting them through fast as we can without compromising the integrity of the program. There is never a program that's sitting here like, hey, we need 5 more people in here. It's constant. Those guys are waiting. They want the programming. They like the positive reinforcement at the end. A lot of times this is where they get it. But yes, for effectiveness, we have found that the guys that are more engaged in our programs and are able to earn the program credit are able to be more successful when they release, as opposed to the residents that don't earn anything.
I use one number, Melissa referenced earlier, that if they're in a private industry work programs, we have 40 private industry partners that are either on-site or off-site, where these guys go to work and they're paid whatever the prevailing wages in the community, and we have some great private industry partners. If we have statistics that if one of our residents is in a private industry program for 6 months, a minimum of 6 months or longer, they're 1/3 less likely to return. So it improves the recidivism rate by 1/3. That's pretty good. That's a pretty good return on investment.
And I think like you can layer that out, right?
Yeah.
So I think when we think about the effectiveness of the programs, we think about, are they coming back to prison when they release? And there's so much more to it. And so I love the way that you talked about, what does the time inside look like?
Yeah.
And I think about a lot of guys that I worked with that, had longer sentences and weren't eligible for some of the programs until toward the end of their sentence. So then you're unpacking decades of not doing things. And so then the time that you have to do the work is so shortened that you've got so much more to unpack. And then they're releasing. And so hopefully you did a good job. But I think the behavior in the facility is huge. And a lot of folks talk about when you can engage in programming, we see less disciplinary reports, we see less staff assaults, we see less substance use. Like it just really brings down a whole lot of the things. So we think about the environment in the facilities when we have programming, when we have, I'm super visual. So I'm thinking about, you're right, we have space issues. I say we, like I'm still at USD, but like part of my so we, like thinking about the facilities, like we have space issues. There are classrooms and there are staff and there's funding to pay for those things. And I think about the difference between a bunch of people walking the halls and going to class and connecting with each other versus SORT walking down the hall in their big black suits, managing issues because people are assaulting each other. Like those are two very different pictures. And the level of investment, like super frankly, is not that different. Like how much it costs to do these things is where we allocate those resources. So I think, when we see budget cuts, programs get cut, right? Security, we can't cut that a whole lot, right? But when we cut programs, security gets more expensive. And so like weighing that out, I think is a really important point when we're thinking about how we make those decisions.
And I think it's important that these programs that have been approved by the warden have to have been evidence-based to show reduction in offenders' risk. They're not just crochet club or leisure type clubs that they like to do. They actually been evidence-based to show offenders' risk reduction. So they're established programs that have some data behind them. And I do have to point out that sex offender programming does not qualify for program credit. Throw that out there as well.
Do you think there would be any benefit to doing something beyond programming, but more like pro-social behavior types of things, where it's not sit in a classroom and have people come in and worry about the resources for specific programs, but some way to reward people for volunteering to do things and helping out other inmates or other things like that? Like, is there a way that we could figure out adding in some additional credit to encourage those kinds of behaviors?
And there's some creative, like the positive.
Yeah, let me talk about a couple things that are pretty cool. when we put if someone's on a crisis watch, they're threatening or are engaging in self-injurious behavior, we put them on a crisis level watch, and there's different levels. We use a companion program, and that's people from our resident population who go and sit at the door and keep an eye on that person and make sure they're safe. And if they're not safe, then they're reporting it to an officer who comes and we get aid. That's a pretty pro-social thing. We have hospice programs, so it's for end of life. We have a fair amount of our population is aging and they get ill and they pass away. And in those hospice programs, again, we have men and women that volunteer to go and stay and be kind of the motto is no one dies alone in prison. And have someone there. That's pretty pro-social. When you're out on those work opportunities, you have to learn how to get along in the workplace and play nice with others and all of that stuff. It just lends to that socialization in a positive way, as opposed to maybe what they've experienced before they came to prison.
Do you think more people would engage in that pro-social behavior if there was an
Absolutely.
incentive like a credit?
No
to
doubt.
it?
No doubt. No doubt about it. In my view.
Yep, no, I 100% agree with that. We see a little bit with when we can employ some of the case management stuff, because that gives us a little bit more leeway instead of saying you have to sit in this classroom and you're gonna learn this. We can set different things like, we want you to be part of the hospice program. We want you to be, these different things. If that's what their risk level is. But yeah, if we could incentivize some of those things, I do think it would be good. And really the benefit is kind of twofold, because you end up with a benefit to that actual resident, but you also end up with a benefit to the overall population. So absolutely.
It also seems like that would be a way to help incentivize some of the people with the longer sentences that otherwise can't get involved in programs and don't have a real motivation to do some of those things, if they could do some of the other.
Yeah, kind of what comes to mind is, and this has been a little while ago, but I remember there was this resident that every morning he would get up and he had there was this ground and it was sandy. So we kind of called it the Zen garden. But every day, every morning, he would wake up, and this was such a big purpose to him, and he would rake it religiously. It helped keep him calm. It helped, the other residents liked seeing it. The staff, walked by, always made comments on it, which made him feel good. Things like that, when we can work that, and then we can kind of work, he was a very antisocial personality, leave me alone, I don't want anything. And then for us to be able to work him into an area and have those conversations with the other people coming up, that was a win for us. So I think there's a lot we could do to incentivize some things. And I don't see pushback from the residents in regards to any of this. They want this kind of stuff. And it's not like we're just saying we're cutting off your sentence early. You're still doing your sentence. It's just, you're gonna be able to do more of it in parole and on, in the community where you live, where you hopefully we've helped you get a job and you have driver's license assistance and all these things. So very much.
I appreciate Mary's point earlier about the ethics of kind of how we get people into programming, because there's so many pieces to weigh. And in victim services, when we were trying to figure out for battery intervention, we wanted folks who were releasing soon and could get the kind of jump start on their parole-based programming. And there's so much value in the folks who have longer sentences being kind of a peer mentor in the facility to be able to walk out some of those practices in the cell house. And so we weigh that when we're trying to figure out that eligibility, because having folks with that purpose of being the hospice worker or helping with some of those other pieces, it bringing that purpose changes the nature of the facility. So I think your point is super, super solid.
I would also just insert quickly that it's also a balance, right? That we can, and I'll say we as victim advocate folks, right? We can know, the research can express, we can intellectually understand that the more pro-social behaviors, the more programming opportunities, the more education means lower recidivism, which means communities are safer, which means victims are safer. And the optics around the person who killed my child is going to prison for free, or I'm sorry, is going to college for free in prison. My child didn't have that opportunity, right? So balancing those very real, very valid and necessary feelings and beliefs with what we intellectually know works. I would say in our corner of the world is sometimes a very complex and nuanced balance.
And I think that those are the cases that are the loudest and that maybe tug on our hearts the most and should, because I think that's important, right? And I think the majority of victims that I've worked with over the last couple of decades are not the vindictive, throw him away, I hope he never gets out. The majority say, I hope no one else gets hurt, right? I hope that he can be safe when he releases. And I think the more that we can do to ensure that when folks get out, they can be safe. Like if people have a job and some money in their bank account and they're sober, like victims are so much safer. And a lot of folks that we've worked with have said, like, if other people can be safer, great news. One of the things, just like a little thing, and I want to make sure that you hear that both of those things are so important. The victims who say, I wanted to stay in, don't let him out, my kid didn't have that opportunity, that matters. And we got to be weighing the other piece. But one of the biggest things when we saw folks getting ready for a release, so they'd be seeing the prisoner review board, and victims would be coming to speak in opposition of that release, and they'd be looking at Casper where they could see that public information, and it would have the list of disciplinary reports and that kind of thing. And they're like, see, no remorse, he's still having problems, this is awful. And I can think vividly of a guy that I was working with in some restorative justice programming who was incredible. He was so remorseful to the point that he had invited so many other folks in the facility to be really thoughtful about, you know, their crimes and the impact that it was having. And this family is saying, like, he is not remorseful, he shouldn't be considering release, because all they see is the disciplinary reports from like decades ago. And so at that point, we looked at, folks can say, like, they can give permission to release the programs that they participated in. And I would say that's a huge shift for victims to be able to see, oh, he's doing all of this stuff while he's inside, like that. Maybe he's engaging in something. Maybe there's some change happening there. There's still a lot there, like, he's only doing that for program credit. He's only doing that so he can get out sooner to hurt somebody. So those are things that we need to have the language to weigh. But I would say, being able to not just show the negative and to be able to show the folks that were engaging in positive behavior really helped balance some of the perspective and help prepare people for the eventuality of release. Final point, I'm thinking about, like, if 97% or maybe it's more now get out of prison and like they move in next door to me and my grandma, like I want them to be like the very most successful that they can be. And when we're framing the conversation in that way, like very few people are getting locked up forever. That's not what we're doing, and that's not what we should be doing. But I think the what we do with them while they're there is a piece that we could be talking a lot more about.
I'm so glad that both of you brought that up. I have some questions about that issue because I agree. Intellectually, I explain this to victims, they get it. What I hear frustration-wise is people get a certain sentence and it's never the real sentence because they go to prison and then you guys have all these regulations that nobody really knows about and they get all these credits and it doesn't get added to the post release because they also get credit off the post release. So where they think they're on post release for 36 months, they're not on post release for 36 months. They get released early, like, and you're right. The hardest cases are the loudest voices. I get that. So trying to figure out how to balance those as well as provide actual determinate sentencing is not necessarily the right word, but that's really what victims want. They want to know that if they are safe for 18 months, for some of them, then they're actually safe for 18 months. And in their mind, generally that means that they don't have to worry about running into that person at Walmart for 18 months. And what throws them off with some of the program credits, the good time credit, which again, I agree with all of that and the need for us to do that because they're coming back out. What throws them off is that suddenly seems to get awarded on some things, or it suddenly seems to happen, which you guys are working on it from, you know, day one. They get it last minute and then they get that frustration. And I feel and I'm not a public official who makes these decisions, but the resistance then that the issue gets to the legislature is that's what is then seen is that we're just releasing defendants left and right. And we're not actually being victim aware of some of the consequences or the expectations that victims have when it comes to those types of issues. And so you made a couple points about the program credit getting added to their parole time. But isn't it also true that they can earn good time off of their parole time?
They do earn, yes, they do earn the good time off of parole time as well.
So are there ways, and they go to the public Casper website, I checked it as well. Are there ways to put on like notifications or at least information there? Because I myself have been surprised when I've gotten a call from a victim to say, so-and-so got out today. And I was like, what are you talking about? He's only been on parole for 12 months and it was supposed to be 36, stuff like that. Are there ways that we can be more transparent about some of those things with still protecting, you know, dignity and privacy, in finding that balance?
I think a large part of it is education. KDOC, all Department of Corrections everywhere has so many rules and so many different policies and things that everyone's doing. And honestly, victims, if they haven't had any experience with the criminal justice system before, they're not going to be aware of it. So they're like,
in this system who have worked, most of you have worked in this field for decades, and you're like, how does this work? Like victims of crime, they don't know any of this, yes.
yeah, so,
And shouldn't, have to.
you know, they're hearing, oh, you're going to be in prison for 10 months. Great. That's what they expect. You know, there's kind of, and then they come to find out, wait a minute, you're not going to be in prison for 10 months. Now you're getting out at 6 months, or you're getting out at whatever time. That is a huge blow to them. And that, I mean, that would be to anyone. So it has to go towards their feelings of safety and everything. I think that's where maybe more education and working together on the part of victim services with classifications, and to include prosecutors and attorneys and judges and everywhere. I think everyone needs to be aware of what could possibly happen and how to look at the sentence.
I have a shameless plug, and I'm gonna jump in here. Because I told you all at the beginning of our panel that our office has 44,000 registered victims. And that we provided almost 20,000 notifications last year. What you may not know is that all occurred via snail mail. That we do not have the funding or the technology to update victims in real time. So you guys are talking about, you know, program credit 30 days here, 30 days there. In theory, to me, that's exciting. That's fantastic. My mind is spinning about how would we possibly do victim notification around that. Other states have systems where they can do automated notification. So theoretically, you could in real time be notifying a victim that yes, originally, you know, the sentence expiration date was going to be X, Y, and Z. But now they've obtained a 120-day program credit, and so now that's changed. And now they've also, you know, getting this good time, so now this has changed. And the manner of efficiency and information that we could achieve if we had the technology to do so. That's my look. The Secretary has been very supportive of
The
that.
key to that would be a system for the entire criminal justice system in Kansas, not just KSSC. You know, because the Attorney General's office does some notification, local entities does notification, and there are systems that if we had that system for the entire state and everybody was on the same state, I think we could do some more robust notifications.
Okay, so I'm gonna gently plant one seed, just from some scar tissue from lots of other states. So Vine is one system, yeah, you're like, yes, I know about this, yeah.
I didn't say Vine.
You didn't say Vine. You didn't say Vine.
Secretary, they appreciate
Okay.
it.
So when the directors of victim services from across the country get together, there is always like a table about automated notification. Snail mail is not the way to go. Statute still says snail mail, which is why we do it. But text messages or emails would be really, really wonderful. There's a great system in Idaho. No, yes? In another
Idaho's using
state.
Vine.
So it wasn't Idaho.
Oregon has a really.
It's not the one I'm thinking of. I'll think of it. But there's another state that developed their own, and it gave them the ability to do some really cool stuff. a lot of folks are using Vine because they have the monopoly on criminal justice information, which is a cool thing. However, occasionally they notify every registered victim that the offender escaped. So if you can imagine, like, calling every single person and saying, JK, like, that didn't actually happen, they're still in the facility, it's okay. But these little glitches that can cause
Yeah.
tremendous panic for victims, and until some of that is sorted out, like, it makes me really, really itchy. So I think it's exciting. And proceed carefully, because they overpromise and don't tell you about some of the problems. So like, if that's a direction that you go, there can be huge benefit to victims, and it literally makes my skin crawl just a little bit thinking about some of the things that unintendedly roll out when you do that.
Can I ask a question about that?
Yes.
Sorry. So Vine is for pre-sentencing, correct? So Department of Corrections does not utilize Vine, is that?
In Kansas.
In Kansas, okay. But in other states, they do use it for other things, yeah. So I get all of that. I also know that there have been people escape from Lansing who victims haven't been notified because you put it in the mail on Friday when they escaped and they get caught on Saturday and Sunday.
At 2 a.m. we get 100% escape is a phone call. So with fancy flip phone that Mary might even have in her purse right now, 100% is a phone call.
Okay, if they're registered.
If they're registered, and also people will also notify the county of their address change, but not notify DOC because we are separate systems. So I do back to that education point of like, from sentencing, like all the way through, the more that we're talking to each other and catching some of those things, the better outcomes for victims. Because you're right, there are several points of notification where things break down because folks, we don't have their address, we don't have their contact information. Thinking about Ohio has a statute that requires victim services to dive in, like super, like stalk victims and find them to notify them of parole hearings. And they're like, how did you find me? And we're like, it's the law. They're like, well, can he find me?
Yeah.
So, I mean, there are all different ways that Duke have handled some of this, but yeah, notification, we could do a week-long institute on notification.
I think that in order for that to get some steam, I think someone is going to have to address both of those issues together, right? So providing more programs for earlier release and incentives, as well as providing more notification for victims on when that's happening. I think if there is a possibility to couple some of that, I think there is a bigger appetite for addressing both of those. That is what the bigger fear is. When you just address program credits or good time credits or good pro-social behavior. Thank you, Josh. Everyone understands that, but I feel like we have to also be able to address the other part of that, to show, because they are elected, to show when they do go to the polls that they're not just letting people out, they're also considering victims and victim notification in those releases.
Yeah, in any time, so if someone's sentence gets changed dramatically, like say they got some good time restored or they get that program credit, it is part of our responsibility to make sure victim services is aware so that they can send that notification to those registered victims. We don't have a good method of handing out people, the notification to people that aren't registered. But they are registered and they do want to know, that's kind of our goal, each caseworker's goal is to make sure that we're notifying them so they can go through and explain that to them.
And I'm not saying that you're not, please understand that
No,
I'm
no.
talking about too. I just know that when it's at the end of that sentence and you're trying to get it done and then suddenly they think they have 4 months and they have the weekend, that's where the biggest frustration I hear.
We very much do have several that end up getting program credit towards the end. And so when all of a sudden you're getting out 4 months earlier with 120 days, if I'm a victim and I'm planning to do whatever and have special precautions, that comes as a jolt. And so I get that. And I think that's super important to remember and something to keep in mind.
And for our facility liaisons as part of release planning, they're looking at, are they eligible for program credit? And this is not 100%, it's not a perfect system by any means. But ideally, they're aware of this could be something that may impact that release date. And I think some scar tissue a while ago, when there were some changes to program credit, we got really tight, with the folks who were making those notifications, and we could catch them sooner, and some of those meant phone calls to victims. Instead of sending letters, especially the folks that we were working with on a regular basis. That happened a lot more, in connection, but I do think if folks aren't registered, or, if we don't hear about it, or like, there are lots of opportunities for that to break down.
It seems like a lot of the breakdown is at the prosecutor level.
We have no.
I'm just saying, if you were telling victims that program credit exists and victim services.
And then they still come up with things that I had no clue about. I mean, Mark just told me something on my old law case that I didn't even know about today, so, you know. There's just, once they get a DOC, what we try to tell them is, please communicate with victim services, because
That's right.
we have zero control from the date that we sentence the defendant, and they know way more than we do, but that's not what the public perception is. The public perception is that we should know, and we should have some control over that, and what we said, the court said, the sentence, when Judge Donovan pronounced a sentence, that's what they believe, and they don't necessarily, connect and follow that when they get to victim services.
So, well, I think what prosecutors could do is try to encourage them to register
Yes,
as a
absolutely.
victim. If we have 44,000, we have 9,500 people, adults in the system. So we've got an average of about 5 victims per resident today. So really, that's pretty high number, I think.
But
So,
they don't limit what a victim is either, which is
Yeah.
yeah,
rather broad.
yeah.
Again, we can have a whole thing, so super quick. No, so I think one of the things, and Scott, you know, this is my little soapbox, so I'm gonna try to step down quickly, but domestic violence is such an underlying issue in our system. I would say about 60% of our population has a clear documented history of domestic violence perpetration that is almost very, very rarely addressed, right? Like, domestic violence programming is minimal. And so if we say your crime of conviction is not a victim crime, but the original call for service was DV, but that got fled off and you came in for drugs. So you're not a DV victim, so you can't register. Their safety is still impacted by the fact that you're gonna hurt them being inside. But if that crime wasn't DV, then, so there are a lot of states that say you aren't a victim of a crime of conviction, you can't register. And we say, if you are a victim, if you need this information, it's public information, you got it. We also don't close cases, registrations, unless people request that because of recidivism, right? So if we close it and then they don't re-register, so we leave that open. When they come back in, we say, hey, they're back. So for that 44,000, not all of them are attached to current people, but a lot of folks come back, and then we know that we've still got that registration in place. But domestic violence would be a place that we could also do a full weekend.
Very good. I know we're almost out of time. I just have one more question. One of the things that we've talked about are offenders with longer sentences. And what I thought I was hearing was that you're triaging based upon the amount of resources that you have for those offenders that are getting ready to get out or closer to the end of their termination date. How do you, if we would consider something for longer sentences that are not currently eligible for program credit, those that are doing life sentences, those that are, you know, level 1, level 2 drug, those type of things, is it going to be from a resource standpoint doable to be able to provide credit to those individuals if you obviously are having issues with well, not having issues, but you're trying to actually prioritize those folks that are getting out? Or I guess my other question would be, you have folks right now, though, that are getting program credit that aren't eligible, right? Are they taking classes that they receive?
So we
Program
have
credit.
people in those programs that are not eligible for program credit, and they complete the class the same as everybody else, they just aren't able to earn those credits. The same way if those that have longer sentences and stuff, if we can get them into. So we don't want to say, no, you can't take this program because it's reserved for only those that earn program credit. We want to put the people in it that want to be there and that need to be there. So as the program supervisors go and they look at who has been referred to whatever program it is, they have to take all of that into account. They take into account release dates, what the risk level was, comments from the unit team counselors. They're gonna look at all of that. Do we have the resources to handle an increased amount of longer term guides? I think that would require us to be maybe more creative in what we're doing with those guys, but I think it's needed. It also would be really nice to take some of those longer sentence guys that say, well, you're not gonna let me do anything until I get closer to release. It would give them an incentive to behave and to progress, because then they can use some of those skills to get a job. They can use some of those skills in the prison. They can use some of those skills to handle the conflicts that they're having with their roommates or with somebody else. If they falter, and honestly, if they have a longer sentence, that's ideal, because we can go back and say, hey, let's refresh on what we have learned, because none of us is perfect. And retaining stuff that you learn doesn't happen overnight. So it's wonderful if we can go back and put together a group, kind of like an aftercare group that refreshes them every once in a while. So yes, I think it would be a challenge with the current resources we have, but I think we would all be willing to do that challenge and meet that challenge.
Well, I think we're at time. Thank you, all three of you. It's very good.
We'll get you some of those.
All right, well, then we're open for discussion. Does anybody have any epiphanies of what we need to do to fix the Senate? Go, Ellen.
I feel like one thing we could do to cut down on that impact would be considering doing a separate credit. For some of those social behaviors, separate and apart from program credit.
Yeah, that's.
Because it also like for safety and security in the facility, so there's. It helps us with that, that also helps with behavior.
Yeah. It doesn't
Yeah.
seem like the cost of that. Those would be as great.
It would not require a lot of resources. I would say resources, which is a lot of
Would we,
Probably have staff who doesn't train for those kinds of things.
Yeah, we already train them, so you train them and you just train more about.
so with that program credit, though, would it be beneficial to reduce 120 and put, you know, if you do battery intervention, that's a 26, 29 program, so maybe 100 you need for that, but if you want PVC, which then it only takes you 2 weeks, you get 30. I mean, does it need to, credits need to be weighed on?
But not everybody needs battery.
Well, I get that too, but you know, if you're doing. Absolutely. And I understand, but it's the same with probation, right? Do you, does everybody, if I only need this, do I get the same for putting it to work? If somebody else did for 4 months of work versus 30 days. You get the same credit. And I know that's an issue.
I think the incentive of the credit, but back to Melissa's point, is it draws them to whatever you're trying to lead them to. And sometimes that's a barrier. A lot of these folks don't want to be engaged, like, well, it's an education. A lot of them have not had much success in the education system. They really have a lot of anxiety with it. It's just, I can't be successful. If you can incentivize it to get them to come and win that GD and then they have a little bit of success, that's what this, and I think if you diminish it, it just, it creates less incentive, for them to at least get their foot in the door and try.
Well, we know looking at some other states that, other states are very generous with their credits that they provide. And granted, excuse me, we have In most instances, obviously the 15 or 20% good time credit. And as well as the current 120 on program credit. Many of the things, and I talked about this before, we've actually looked at increasing credit time from 120 to even 150 or 160. Part of that is we have folks that are staying so short a time in the facility that increase is essentially de minimis. The laws of diminishing returns start to kick in. However, that necessarily wouldn't apply to those folks that are doing longer terms. And so that's one of the things that I asked John to actually do an impact on the program credit to kind of look at some different scenarios as to what what potentially we could actually be looking at as far as bed savings are concerned. Now, I think the key issue here obviously is to kind of identify what it is, but also how long we're actually talking about. Because like I said, other states provide for, in some instances, for the education, for example, they'll give 10% credit off of your sentence. It isn't a number of days. It's actually, you get your bachelor's degree, it's X number of days, or it's a percentage of that. And so for those folks with longer sentences, certainly a percentage certainly would actually be, the 120 days off of a 20-year sentence is not even a spit in the bucket. So if we're looking at thinking about incentivizing in that capacity, I think that we need to actually be able to look at that. Now, keep in mind, and John can chime in here too, when you look at on-grid program credit right now, some of those offenses that are actually getting the 120-day credit that are eligible, that actually equates to, what did you say, 30%?
Yeah, if you're 120 days on a 10-month sentence, I mean, that's a huge chunk on someone who's not there for a very long period of time. So if you're gonna be there for 20 years, 120 days is not like Scott said, basically nothing. So, yeah, anyway, get back on what you're saying. Go ahead.
Yeah, so when we look at someone that is, doing a life sentence and that is going to be, you've got, 25-year sentence before you're eligible for parole. Again, 10%, 15%, 20%, what is a good number to try and potentially incentivize that particular individual to actually do something while they're in the facility for a long period of time, which will directly affect officer safety and, hopefully get them going down the path sooner than later. I do have in your packets, we do have a prison bed space impact as far as retroactive program credit. And we kind of, again, what we were looking at is there are offenders in the system, and this is specific to those offenders that are not right now eligible for program credit. So just those offenders, if they were to actually be allowed, which are D1, D2, and N1 through N3 and off-grid, if we looked at giving them program credit up to 5, 10, 15, or 20% of their sentence, this kind of gives you an idea of what kind of reduction we're talking about. Certainly the first couple, as far as the first years, are not very significant. But obviously by the 10th year, we're talking hundreds of potential beds. And John, you want to kind of talk about that, please?
Yeah, so for this, as you can see, it's not a small group of offenders either. It's roughly half, just under half of the prison population falls into this group that doesn't get any credit. So and this is a little different than what I normally do, but when I'm breaking it down by severity levels, this is the average amount of months remaining on the sentence. So that's why in the first year, if we were to retroactively apply this, it's not as though, oh, the prison doors are just opening up. It's, if you are limited to a percentage of the amount of time they can earn, they have their sentences are so long that it's not as though you're going to see this just magical door open, but by year 10, and honestly, by, year 5 and forward, you're starting to see some major significant bed savings. And kind of piggybacking on what Jen Roth, and her figure had at the cost associated per offender. If resources were an issue, if you're looking at almost a 500 bed savings in year 10, times 40,000, I mean, you're over $20 million in savings right there. So if there were issues of, well, how are we going to fund this? Just the sheer, decrease in beds that we're going to be needing would make a huge dent in that. So all those numbers, the first one is 5%, second's 10, and 15, and 20. I do want to make a note, if this is not applied retroactively to these particular groups, it's meaningless. So you're not going to see, maybe 15 years before you saw really any benefit if you didn't apply it retroactively. So it has to be a retroactive application. If it was going forward on N1 and N2, it could be longer than 15 years before we saw any real major impact. So this is retroactive based on the average sentences of those offenders who are currently incarcerated. Year to year, that's going to be remaining the same. The model also factors in, there are people who are going to be released anyway, which is why part of the year 1 numbers are fairly low, is because even without the credit, there was going to be people in these groups who are just going to be released anyway. So we do start to see sort of a stacking effect long term. And I know that a lot of the times when we're doing legislation, we want to see early impact. This is one that is a bit longer term and forward thinking. But I mean, as you can see, we generally aren't pulling impacts that have, over 400 beds. And this would be fairly, it's pro-social and it's trying to get people, it's not just a, hey, be good, we're increasing your good time by 5%. It's actually requiring folks to get out there and do something from a program standpoint. It would allow KDOC to have the ability to dictate whether or not it was going to get rewarded. And from a legislative standpoint and from a clarity standpoint, if there was a percentage of up to X amount, I think it could still be when you're talking to your victims at sentencing, that could be factored in so that you could tell them if they are taking part in these programs, they could have a reduction of 10%, 20%, whatever it might be. So if anybody has any questions on this, I'd be happy to answer.
So part of the reason why we went to the high end, because as most of you know from last month, we are projecting to have 1,400 extra beds that we are going to need beyond capacity, current capacity, and that's essentially another Lansing building. So, granted, the estimates are conservative, but at the same time, the issue is real. We're back to pre-pandemic levels, and so this would be a what we think would be a win-win for most because it's still requiring an offender to actually be intentional about their journey while incarcerated, but at the same time, they're hopefully getting some beneficial programming for them when they actually are released. Any questions?
I'm assuming we would need to increase funding for immediately. Which, you know, we have to, that's pretty intentional, right? We have to say we need X amount of dollars to be able to add more batterers interventions. It sounded like that we're pretty full right now, but if you're gonna increase this population, you need to be able to articulate, you need more funding now, but in 10 years, we will save 5 million versus spending 1 million today.
Yeah.
But would we have any idea of how much money?
We'd have to put some numbers to the resources, but yeah, but cost avoidance, if you implement the proposal, and then it'd be just a small percentage. You know, John referenced 15 to 20 million, that's operating costs. That's not to build that prison that we're gonna need. You know, that's probably $400 million, right? So a small percentage of that we would do in conjunction as an ask to see if we could get those resources.
And just like Melissa was saying, they are prioritizing some of that. So if it was, you know, year one, we're slowly getting some of those folks in. It could build upon itself that, you know, hey, we don't have the funding immediately, but we are going to earmark it so that those offenders who are in, maybe they have 3 years left. Well, we're gonna still prioritize like we have been doing for a year while we're building up some of the ability to get them that credit. That may not be what we want or want to ask for, but realistically, because this population, I mean, the average sentence remaining on an off-grid offender is 190 months, basically, so we would have some time to work towards getting them that program credit, even if it wasn't on day one.
And my only other thought is on off-grid, and maybe Senator Haley could talk a little bit more about thoughts on, you know, what would be the appetite of pushing off-grids, you know, when these are most serious people? Is there an appetite of the legislature would push that through, or do we look at only doing on-grid offenses?
Well, I think, don't you have a backstop with PRB to be able to, even if they've worked these things, they have a process in which they are reviewing the performance of the resident. And that if this is not a genuine type of situation, they make that call, right?
It pushes their full eligibility date up, but it doesn't guarantee the release date. That just means they'll be eligible sooner, and so we'll look at their.
And
Look at them sooner.
from my perspective too, as was mentioned earlier, the truth in sentencing, especially when we look at those others who are involved, not just from the standpoint of what the public is clamoring for, but those others who are disaffected victims and what have you. To look at what, you know, the grid is, or if they're going off grid, whatever it ends up being, whether it's off grid or whatever, as long as there's I think from the public's perception, that is an accurate interpretation, that whatever is meted out by way of the time that they're serving, that is actually what was contested with both time.
And I think that goes to like what a prosecutor is going to be able to tell their victim. So if they know it going in, and we all know charges get manipulated all the time. So if that's the sticking point on a 40-year sentence, that 4 years might be on the back end, we'll know it and say in 36 years, we'll have an idea. So you'd be able to give concrete numbers, and I think that's what's important.
The other facet of this, of course, is this impact only covers those that do not receive program credit currently. The other facet, of course, is then looking at those that currently do and saying, is 120 days enough? Shouldn't we be allowing for the more that they, you know, care to consume? It's kind of an all-you-can-eat plan, or should we look at giving them more credit than what they have right now, or based upon the offense or the time that they're spending, X number of percentage? That would be another option.
Yeah, because if you're at level 5, having over 120 months, especially on consecutive sentences, you know, it's a very likely possibility. So 120 months on 120 days, 4 months, 120 days, even touching that 10% number. So you could potentially see greater decreases in that middle population. And if you guys remember on the prison projections, that N4 through N6 is also a pretty significant chunk of the population. So we could easily see some more bed savings in that group if you were to increase it to a percentage as opposed to capping it at 120 days. For 4 months. So anything over 40 months, if we're selling 10%, you would start to go from, you, depending on what percent.
Would it make sense to combine those ideas and do a percentage, but it's not all or nothing? To incentivize people to earn more by doing more. You know,
Or just like up to
up to
that.
10% or. A structured way of saying
And
what you do to get that.
that'd still be concrete so that you can tell the victim,
This is
if
the
they
maximum.
do everything, this is the maximum they, or the earliest that they can get out. I don't know how that would work at KDOC, so.
On Casper, when they showed the earliest possible release date, does that include the idea that they could earn its program credit?
Now, how that's me, it's a.
Yes, yes, it does.
Okay, well, then that would be easy.
We were just talking about that, it shows earliest possible release date, but I don't know if that's good time that they earn, or does that also include program credit that they can earn?
That includes, they earn everything.
That everything
That's why
that's
the
possible?
program, yep.
Okay. Thank you.
Well, what do y'all think? Because we can write it up any way you want to. We can come back at October meeting and have another impact based upon what we're talking about, you know, 10, 15, 20%.
You know, sure, you do. Compared, you mentioned other states have a percent. Like when we were on the Criminal Justice Reform Commission looking at probation, you know, Kansas's probation time is one of the shortest in the country.
Right.
What are our sentences like compared to maybe some
Yeah.
state that gives 10% credit? Are our sentences the same as those sentences, or does that make sense? But
One of the
that we
articles,
would be getting.
one of the articles that I read held Kansas out as actually almost like an outlier for restricting, and that was, keep in mind, it was kind of a blended good time program credit type of article. But they held Kansas out as an outlier because we are so stringent on the amount of time that we have. There are other jurisdictions that are even 1-to-1 for every 1 day you spend, you get 1 day credit, which is totally, you know, and, you know, Texas where you're spending, you know, getting 50% good time and that type of thing. So I think in that, you know, if we're wanting to do comparisons, I think we've got some ground to give with regard to that. And it's not going to look like in a setting like you said, Spence, that, you know, we've got Minnesota that has 40-year probation terms. You know, so ours would paltry compared to that. So so I think there's some room there. But I you know, I really think that you know, there's some room here for us to have a win for safety, for the facilities, but also still be able to be transparent on the victim side by saying, this is, you know, it may not seem like it, but it is a good thing because we have offenders that are actually doing these valuable programs to help them so that they're not going to come back and reoffend, you know, as a preventative and hopefully a lifestyle change for them.
And Spence, following up on your question, I think for these crimes, the penalties across the nation are gonna be pretty similar. Not saying that like indeterminate burglary, state to state could have a huge varying range, but the off-grid stuff is gonna be really similar from state to state with heavy punishment.
What about Kansas offender registration?
What about it? So you also have an impact there. And this was based upon a specific, full-scale, nuclear repeal. Just to kind of, and we, we did that, not thinking realistically, but at the same time, wanting to give you an idea of what kind of impact that actually would look like. John has included in here the assumptions that we made based upon the three parts of that. The first part being that no offenders have to register. The second, we've divided the groups up into what registries that they are right now: sex, drug, and violent. And that the impact totals are applied to evenly to each of the groups. And then the third was that CORE is repealed and applied retroactively, which then, of course, would contain quite a few beds as well.
That's why on that last one, if you look on the second bullet on the third assessment, prison beds are so high. Because that is a literal retroactive application. If you're currently incarcerated for a court violation, you would be released. So if anybody's wondering why that is so high, perhaps from a realistic approach, that part two, if we were to get rid of the drug registration or violent or sex, whichever one it might be, you could parse that into the three. So then the top one is obviously all combined without the releasing everyone who's presently incarcerated.
Can we go back and look at the numbers of people who are registering when Violation of Offender Registration Act was a level 10? So between 19, we go from a misdemeanor to felony, to the period where we jumped up to the tier.
What year was that?
So that would be between 1999, it went from a misdemeanor to a non-person severity level 10 up until 2006 when it changed. I mean,
With every year we go backward into the early 2000s, the data problem is slightly less reliable because the data was newer. We were revolutionizing the journal entry. Quinlan was getting everything rolling. I can go back and look for certain. I cannot predict the reliability of that off the cuff. Well, we could see right when that first year of felonies occurred, how many felonies we saw in the early 2000s. We could certainly go back into the early 2000s. I don't remember offhand. I think we have some data back in 97. But I know that our journal entry looked a whole lot different, and some of the data that we had was obviously not nearly as robust. But we can go back and see.
well, and that's only gonna give us information on the sex offender registers because we weren't registering for the other things during that period of time.
But
either.
I hate to just continue to pile on how hard this state request will be.
You're welcome.
We can also each given year see when the drug, see when the violent, and we start to see. You could potentially see a year-to-year increase and decrease. Obviously, during COVID, we're gonna see a decrease, so keep that in mind. If you were to look at the data, everything decreased during COVID. But
I'm looking on our files and we have all the impacts from 2000, right here, from 2005 forward.
2005 forward.
Well,
If
and
we had the databases though, I could rerun it.
Kuban has those, and then Kuban.
Yeah, so I just don't know how the
How
data
reliable,
got better
right.
as we've aged, so.
I don't know.
But
I
I
mean,
can certainly try.
I'm just asking about that. It just doesn't seem like logic, best practices, scientific data is convincing to people. So maybe that's a rabbit hole we don't necessarily have to go down, but if it was something that we could get, because I did notice that one of the things that you said is the Sentencing Commission does not have readily available data regarding the underlying conviction for the offender registration. So if we don't have that now, I'm betting we didn't have it in 2000.
I can extrapolate it kind of from like the data that Jen brought up from the registry itself. I would imagine the percentages are really similar to what we see, like just from the big four counties, those breakdowns. Like Johnson County was almost an even third split. Sedgwick County had a slightly higher sex offender, a couple other counties were slightly higher on the sex offender. So we can probably extrapolate that and make that assumption. Based off the KBI's data, it wouldn't be perfect, but I think you could make an assumption off the KBI's data on who's still registering. Also keeping in the idea, it could be overrepresented by the number of people who are registering for sex offenses because that registry is longer. So you're not getting rid of the sex offenders as quickly.
That's true.
So maybe now I'm contradicting myself on whether I can make those assumptions because I don't know if I would know what year their conviction would be. They would just show up on totals for the registry. This is obviously not quite as big, as the program credit one, but, this group was serving, I think it was 32 months, and that's after jail credit, so they're definitely stacking for a few years in the system when they're going in. It's not, oh, hey, they have 6 months to serve type of a deal, and they're out. So it's not even really like a parole violation situation. Oh, they're coming back in for the maximum of 180 days. Parole violation, they're actually coming in and doing a few years on average. So some of the folks are doing longer.
Do we know, John, you're probably just getting off the top of your head, how many departures we get from Cora violation?
I'd have to look. I don't know.
Come on, I'm so excited. And I'm just curious, again, if we move forward with legislation to be able to provide, hey, judges aren't sentencing to prison for Cora. So does it make sense, maybe even just, throwing out ideas, even if we change registration offenses to a level 10 versus a level, 6 offense?
We still have almost 50% of that population going to prison.
Okay.
So
maybe,
and with most of them being, the 3, 5, 6, 3s are all going to be presumptive, most of the 5s, because you're not registering unless you have a person felony.
Right.
So that's the issue too, is that group has a higher criminal history than most because they're going to have, unless it's a drug, a person felony that they're registering for, so they're immediately at least a D.
Well, they're not getting counted for that.
Yeah.
Oh, be an enhancement, so.
Okay, never mind.
Well.
But
we
if
do
they
have-
get more than one, if they have 3 counts, they're getting
Right.
counted, they're a B.
Yeah.
Okay, I got the impacts from 2003, but then that would come to it.
I'll have to go back. I'd like to rerun them all.
Well, so, and we do have time and expense, if you look through here. the
Okay.
Level 6, 8, 9, probation, 64% of the time on 6s,
Yes.
68% of the time on 8s, and then 100%, but there's only one on that, so.
Thanks.
When do we have to have, if we want to do proposed legislation, give us timelines on that.
Tomorrow, no. I think, we can actually work something else up for October meeting. Look towards, maybe solidifying something at that time, or even November. That if there's other issues, of course, you've got in your packet, you also have the felony theft that we've been trying to do for 6 years. That kind of gives you a difference between lots of beds and 2 or 3, which doesn't move the needle at all for us, but at the same time, that's legislation that is common sense in terms of being able to bring all of those non-person folks up with theft and the other mistreatment of a dependent adult.
Does the commission have any appetite to rerun something that I really like, that I don't know the legislature ever liked, the drug grid, moving the possession grid to look more like an 8, I believe is what we've decided.
Yes.
We can rerun that. Okay. I don't know if there's any appetite for that, at all, but we ran it a few times.
Hard to tell, things are gonna be a lot different this year.
Okay.
Well, we can actually, work on these two topics, and try and maybe bring some more scenarios for the members to consider. And then just kind of look at it and see what, it may be no, that, that's not plausible, or we could break some things apart, if we end up combining them. But I think, just continuing the discussion on this was very helpful to at least be able to understand some of the points that I think people were interested in, so that we can actually go back and create some of the potential scenarios that on the program credit, and then maybe on the offender registration too, that we could work on fine tuning that as well.
And moving, let's, in imaginary land, if we moved all failures to register back to a level 10 non-person felony, that doesn't have any impact on the federal money that people so want, but don't understand it's so much less than what we're spending, right? Because we still have the 3-tiered system.
Well, we'd have to have a 3-tiered system.
Well, you do in that the length of time, I guess that's not the tier.
Right.
Is the tier the time?
Right.
Oh, and the time, never mind.
So we would likely not be in compliance at that particular time, but again, has been illustrated today, we're talking a couple $100,000, in the grand scheme of things, which, I think, when we look at Judge Huffman's, recommendations or some of the questions to ask in terms of since we've actually implemented, the registry, has, if we have the ability to do that, have sex offenses gone down? That would be an issue to explore, that if we see that there's no difference whatsoever, again, that corroborates, the ineffectiveness of the registry. Some of the things that were suggested as far as relationship between the victim and offender, that's something that, I wish were in the journal entries, but they aren't. I suppose they could be in the PSIs, but that would be a pretty heavy lift to try and have to go through all that and try and determine in the, that presumes that the victim impact statement would actually include something like that. So, yeah.
We could put a little box in the journal entry.
The other thing too would be, I think, the current cost of implementing the current registries is, I think is a valid question. How much does it cost for sheriff's office statewide to actually, implement the law? How much are they spending? How much are they actually receiving in offender payments? I can't imagine that that's offsetting the costs of what they're paying deputies to administer the program. So,
And if I recall, isn't one of the major opponents to this kind of legislation is the utility of law enforcement? If we were to have some evidence that it's not really, it doesn't have the great utility that they're always claiming, that might be useful as well, so I can look into that.
The cost and the benefit, the cost to sheriff's department center might be a post audit request. That the legislature could request for you.
where could we find a legislator that would be willing to make that request?
I think I can still do that. Just send me an email, we'll talk about it.
Okay. What else? Any other thoughts?
After one thing out. Question for Secretary Zamuda, question for you, Scott. Would you support a bill to change the requirement of mail notification for victim notification? And is that within our scope? Be a softball.
Well, yeah, I would support it in that maybe just broaden it to, could be by US Postal Service, by email, by any means, call, that type of thing.
I think it would probably, would you have a fiscal note that may be attached to that based upon if you were going to automate something like that?
Yeah, yeah, I need to, again, if we're gonna automate it, I'd like to see if we can get all the players together, get
But
everybody.
you have cost savings in not mailing
Yeah,
stuff
that's for
versus.
sure.
Well, I guess I would draw that suggestion.
Well, but changing the language
Yeah.
to give you a
Yeah.
choice
Yeah.
isn't
That-
mandated,
That's right.
right?
Well, I got a 21st century solution.
Well, yeah,
That's,
I'd like to see
methods
a
of communication.
coalition come forward, not just KDOC, other players and say, look, we need a network system would be beneficial for all of us. I think that's what we need. But we can change it without fiscal impact. This gives us options. So yes?
One thing, big ticket items, right? That this commission, we've looked in the past, and I think Jessica brought it up last meeting about looking at the whole sentencing grid, right? That's no quick fix and obviously a lot of work for us, but the other thing, we focus so much currently like looking at probation, looking at prisons on drug treatment, right? What that's so prevalent right now, it was mentioned by our panelists, it was mentioned, in the meeting in KUC, mental health treatment, and how do we, it's so, I look at it from probation, so cost prohibitive for probationers to get mental health treatment, if they want an evaluation, that can cost hundreds of dollars. It is hundreds of dollars, and, generally, they don't give you a fixed scale for probationers or a sliding scale if it's court ordered to do treatment. So how, and that's something that could impact, I think, overall bed space, if we can address that early on, or even after, recidivism rates, but, what's the mechanism that we work as a commission to address how we pay for mental health treatment? I think if we look at it, I think Elliot could certainly add that to his plate with Senate Bill 123, that we could add, Senate Bill 456, Senate Bill 456 is all mental health treatment, right?
Triple the budget.
Add that, but, that's something I think as a commission, we could certainly look at how to address that. I don't know how. Because it's gonna be a financial impact for sure, but I think the bed savings overall would be probably pretty big. I mean, the state are having mental health summits where, had a special commission, what was it, 2 years ago with the legislature on mental health. But yeah, where does that lead us as a commission on how we look at our offender population?
So prisons become the largest mental health.
Right, absolutely. And it's prevalent. I mean, you mentioned that there's just not enough mental health providers that will even do work in prisons, but it's so needed. And it drives so much of our thinking that, that's something that I think can certainly be addressed. I don't think you can get your legislation put together next week for it's done, but how can we better provide services to keep people out of prison with mental health spaces?
And the expenses, peers in community corrections and our parole officers would tell you, there's just not the resources out in the community. So a lot of people are failing their supervision. In part because they can't get
I
treatment.
mean, you're ordered to get a mental health evaluation and it's $600.
Yeah.
And if it's court ordered, a lot of mental health providers will not give you a sliding scale like they would your average person who wants help. So how, and so it absolutely, you're ordered to do it, but you can't do it and you fail and you go to prison.
You go on medication, you go on crisis out in community.
Right.
Police don't know how to deal with you, you get arrested, go to jail, convicted, in prison.
Yeah, I mean, mental health is so big.
And it's actually not that crazy of an idea to put into Senate Bill 123, right? When you look at, the providers that have moved to the CCBHC model, that are now offering mental health and substance use disorder treatment, obviously there would have to be a significant funding increase, but, that population we know needs it, to your point, so.
Johnson County is a mental health court. It seems to be
There are several now across the state, yeah.
Again, if you can show a cost avoidance to incarceration, that's how you pay for it.
Right.
So if you roll it into Senate Bill 123, how many people need both?
Exactly, yeah, it's not gonna be a.
The population.
Yeah.
And I think there'd be a little more appetite in the legislature. I know a lot of things are gonna change, but, we've had committees just recently dealing specifically with mental health and looking at the judiciary, having summits on mental health across the country, and the behavior courts, and I think there'd be a little more appetite now that we used to for it. It's so prevalent.
Good topics. Okay, well, we will work up some things on those. Any other ideas before we adjourn? But we have had a discussion. All right. Okay.
All right, we'll hear a motion to adjourn the meeting.
So moved.
Second,
Second.
thank you.
Thank you all very much. Thank you. Well, thanks staff for putting all that together and helping us. Thank you for attending today. Give that to Brenda.